may I mention something? First of it, primitive time is going to last on till 12th primitive time is there. And I have filed one interlocutory application. And I have also do. I have for ignoring some defect. Defect only related to that the decree has been sent to the learned court. हाँ 12 तक हाजिर करके लगा दिया हम बाकी सब कर देखिए.
From the supplementary list under heading for orders, withdrawal of cases, item 1, BA 4320/2026.
BA number 4320/2026. The Learned Council for the Teachers seeks permission to withdraw this bail application. Accordingly, this is dismissed.
Under heading for fresh filing, item 2, BA 4126/2026.
It's not possible.
Under heading for admission, item 3, BA 3928/2026.
Alternate file. That's it. Counter policy. Yes.
Yes. From the period of the case the place of occurrence, there is a recovery of bladder stone as well as the stone and the belongings of the patient disease from the place of occurrence. Thereafter, he was seen by the informant as a last seen as per the 106 of the evidence.
Where was he seen? Where was he seen?
No.
Not at the place of occurrence.
No. As per the first written complaint of the informant.
Where is the epistle written?
I am coming.
Epistle report appears to be the only link.
एफएसएल रिपोर्ट की जो उसका डीएनए जो हुआ है वो डीएनए अभी तक नहीं है.
कहाँ?
भेजा गया सैंपलिंग के लिए.
कब भेजे?
बट डीएनए जो भेजे पैरा 88 की जो है
कब भेजे बताइए.
ये 14/5/2025 को पैरा 88 89 पैरा 88 89 of the case study.
Okay.
Rest of the para 94 of the case which was received by the for the next developed case para 94.
It's a case of practically it's a case of last scene.
Last scene. The fact इनको knowledge अब बाद में इनके वाइफ जो बुलाते हैं कि आप आइए सिंटू कहाँ है, डिजीज कहाँ है, वो बताया नहीं, और कमाने का बहाना करके वो छत्तीसगढ़ जब डिजीज का डेड बॉडी रिकवरी होता है तो ये आता है, क्रिमेशन करके फिर चला जाता है। ये सब ऑनर्स है कि नहीं, ये क्राइम नहीं
Suspicion तो है.
सस्पिशन तो है कि लास्ट सीन में
Last seen after the occurrence. And lastly, he was seen, he came back, and then the wife asked him where is he. Then he said that he is somewhere. Yeah.
yes. Satisfactory explanation not been given by the protagonist. तो the informed.
चार्जशीट तो हो चुका है ना.
हाँ 4 से 5
कस्टडी कब से?
15/4/25 से.
BA number 3928 of 2026. For the learned counsels appealing on behalf of the parties, the learned counsel for the petitioner submits that except confession statement of the petitioner, there is no other material connecting the petition with the alleged offence.
Other witness का 161 का statement है.
आपका कोई eyewitness है?
ये eyewitness कोई नहीं. सब कुछ लोग relative है.
The learned counsel for the state has opposed the prayer and has submitted that the DNA sample has been sent for examination by FSL, but the report has not yet been received. He has further submitted that the present case is a case of last seen. It is a case where the petitioner was last seen by the last seen along with the deceased. He submits that after the commission of the alleged offence, when the petitioner came back home, his wife asked him about the deceased, her neighbor. And he told her that he had left him at housing mode. The learned counsel for the petitioner has submitted that considering the custody of the petitioner be released on bail.
इनकी बड़ी बहन जो स्टेटमेंट देती है.
इनका
बड़ी बहन है सरिता कुमारी.
eyewitness है.
eyewitness नहीं है.
क्या है?
पिंटू ने कन्फेशन में बोला है कि जो डिजीज का मोबाइल और 3000 रुपये ये उसकी बड़ी बहन को दिया, इन्फॉर्मेंट की बड़ी बहन. तो वो बड़ी बहन जो एक्सेप्ट के 161 ये इन्फॉर्मेंट बोली कि जो मारने के बाद इसका जो मोबाइल खर्च हुआ वो 3000 रुपये इसकी बड़ी बहन को.
सीज हुआ बड़ी बहन के पास से.
बड़ी बहन के पास में सीज तो
नहीं है ना.
नहीं.
After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and as of now, except the confession statement of the petitioner, there is nothing against the petitioner. The petitioner is directed to be enlarged on bail. However, FSL Ranchi is directed to ensure that the FSL report with respect to the sample forwarded to the said authority as back as on 14/5/25. Cup forwarded in this case कब फॉरवर्ड किया है FSL?
16/5/25
As on 16/5/2025, we forwarded to the concerned court at the earliest.
और रिसीव हुआ है 16/5/25
As the trial is in progress and FSL report appears to be an important evidence in this case. Counsel for the state is directed to communicate this order to FSL branch. Let this order be also communicated to FSL branch by the office of this court. And this order be communicated to the court concerned. विड्रॉल का ना अलग से डेटा मीटिंग हुआ
जी From the daily list under heading for fresh filing, item 1, DA 4200/2026.
You see page number 4.
Page number
4.
yes.
Para 6.
No criminal antecedent. That is your only ground. Custody कब से? Custody कब से?
15/6/24
Trial का क्या stage? Trial का क्या stage? Stage क्या है? Trial कब से चल? हाँ? और क्या कितने witness examination?
2 witnesses, including the victim, have been examined before, and the next date was 13th Feb 2026. Some more might have been examined on 13th Feb.
How many witnesses are there?
16.
16. Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petition has been falsely implicated in this case, and the petitioner has no criminal antecedent. He is in custody since 15/16/2024. The learned counsel for the state has opposed the prayer and has submitted that the allegations against the petitioner and other co-accused are very serious, and trial has already commenced. Out of 16 charge sheeted witnesses, 2 witnesses were examined till 13/2/2026, and a few must have been examined in the meantime. Heard the learned counsel speaking on behalf of the parties, and considering the seriousness of allegation made against the petitioner, and also the fact that the bail application of the co-accused, namely Chandan Soren, Vivek Soren, Manvin Marandik, has been rejected by this court in DA number 6302/25 and DA number 7464 of 2025. And trial is going on. This court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses be promptly produced before the court. Counsel for the state is directed to communicate this order to the concerned court and also to the director, to the SP of the concerned district, and also to the director of the
Item 2, BA 4204/2026.
114 years. Kindly see page number 4.
Who are you? With the husband? She was found dead in matrimonial home.
कोई witness नहीं.
Eyewitness होगा क्या hanging का? Matrimonial home.
Witness नहीं इसका ये लोग सब जब ये गए स्पोर्ट पर तो सब लोग भाग गए थे. आरोप सिर्फ यही है कि ये लोग से किसी से भेंट नहीं हुआ उसका फैमिली से या उसके हस्बैंड से, और सब लोग भाग गए थे और वहाँ डेड बॉडी लगा.
वहाँ पर
इंसिडेंट जो घर में
घर में मरी है ना?
जी
कितने साल में? शादी के कितने साल में?
शादी के 2 साल के बाद
2 साल के अंदर. सर
और मेंटली डिस्टर्ब थी. ट्रीटमेंट चल रहा था उस दरमियान.
ट्रीटमेंट का कोई कागज बनाए? ट्रीटमेंट का कोई कागज है? मेंटली डिस्टर्ब थी, मेंटल हॉस्पिटल में.
ये ऑर्डर सिर्फ में आया है मैडम, कागज में.
Avoid the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband of the deceased, but the deceased has committed suicide by hanging in a matrimonial home as she was mentally disturbed.
कोई डिस्प्यूट नहीं करना चाहिए इस लोगों के बीच में.
He has further submitted that there is no eyewitness to the occurrence, and on the date of occurrence, the petitioner was not present in the house. And the petitioner is in custody since 13/9/2025. Charge frame अभी तक नहीं हुआ, and charge has not been opened. The learned counsel for the state has opposed the prayer for bail and has submitted that the wife of the petitioner was found dead in a matrimonial home within 2 years of marriage. After hearing the learned counsel for the parties and considering the fact that the victim was found dead in a matrimonial home within short time from her marriage, this court is not inclined to enlarge the petition on bail. The improved order is dated 20/12/2025, and the petitioner is in custody since 13/9/2025. The present status of the case is not clear, but as per the improved order, the charge has not been framed. The next date was fixed on 7/1/2026. The state is directed to ensure that the witnesses are promptly produced before the court. If the charge has already been framed, the counsel for the state is directed to communicate this order to the director of prosecution and also to the SP of the concerned.
Item 3, BA 4205 of 2026.
When has the charge sheet been submitted? When the charge sheet has been submitted? When was the charge sheet submitted?
Law and affair, my petitioner and the informant were classmates and they were belonging to the same class. While studying together, they started talking and friendship converted into love. My they met together in the house of friends of the petitioner, where they have established physical relations and they continued. When marriage was not solemnized, then case was lost. My
What was the age of the victim on the date of occurrence? Age of victim was? Yes.
20.
On the date of occurrence. First occurrence is 26/6/2023. She was 20 years of age.
19, 24 में
Custody कब से?
31st January 2026.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 31/1/2026. And charge sheet has already been submitted. So submits that the victim was major and there is an allegation that in the pretext of marriage, the petitioner established physical relationship with the informant, and when he refused to marry, the case was lodged. The learned counsel for the state has opposed the prayer for bail. However, their posted submission is not in dispute, considering the fact that charge sheet has already been submitted and the victim was major. The petitioner is likely to be an action.
Item 4, BA 4221 of 2026.
legal section in this case will be 300. That will highlight that the informant
You were absconded.
was absconding. What I say is that I was doing labor work in Punjab, and when I returned, I have studied.
There was a permanent warrant sheet against.
That is there, but that was not executed.
The trial is on.
Well, the trial is going on. Two of the evidence witnesses have been examined now.
Till when two witnesses were examined?
When
was
the
the
filing
case
of
filed?
this case, I can say, my lord, because
4th of
thereafter,
May 26.
thereafter,
Mm.
on the last date, 16/5/2026, PWs were absent, and they have been summoned again. So that is the exact same. Now, lords, what I'm trying to say, lords, is that other persons who have faced the trial, they were convicted, but by this honorable court, they have been released on.
They have been released on bail.
Yes.
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
Custody since 4/7/25.
4/7/2025, and he had gone out to earn a living, and when he came back, he surrendered. he has also submitted that the accused persons who face the crime have been convicted by the trial court, but they have been enlarged on bail by the appellate.
Correct.
The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner was an absconder and has been arrested on the basis of permanent warrant and grant of bail by the appellate court in connection with the accused has nothing to do with the present case. As per the bail application, out of 8 charged witnesses, 2 have already been examined, to which the counsel for the petitioner has submitted that for last couple of days, the witnesses are not being reduced by the prosecution. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner and also the fact that the petitioner was declared absconder and has been arrested on the basis of permanent warrant and trial is already on. This court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly used before the court, so that the trial of the petition is taken to a particular point. The counsel for the state is directed to communicate this order to the rescue of the concerned district and also to the director of prosecution.
Item 5, BA 422 of 2026.
Yes,
The petitioner seeks for regular in connection with the case number 346, which was registered under section 65 of DNS, which was state of subsequently charge sheet was submitted. The charge was framed under section 65 1 3 subsection 2 of the observation. 2 witnesses have already been examined as per the trial is concerned. One is the victim herself.
how many witnesses are there?
There are 7 witnesses. My submission, Your Lordship, is that
Victim has supported the allegation.
the victim has supported only the allegation which were there in the FIR.
That's why she has to support the FIR.
My humble submission, only one submission in court, Your Lordship, is that there is no corroborating evidence so far as the entire investigation is concerned, as well as
In a rape case, if the testimony of the victim is trustworthy, that's sufficient.
that's
to
sufficient.
convict the
But
person.
that is why my submission is that her testimony is not trustworthy, because first, age is doubtful. Why? Because she is stated in the chief examination in chief that she is the student of madrasa. And police during the course of investigation has obtained a certificate from Adarsh Gramin Public School, Jammu. Victim has not stated that she was ever been the student of the Adarsh Gramin Public School. And so far as official report is concerned, Your Lordship, neither the official of the victim's clothes nor the official of the
FSN will come. When
official.
was the FSN sent?
It is all
When was it sent for FSN? Since when are you in custody?
21st of January 26.
So far as the issue of madrasa is concerned, she is involved in both the cases. The thing is that the school has a proper involvement, and there she was going in the evening for local teaching. That is not contradictory in itself. Second of all, Lord, so far as the FSL is concerned,
She
It
was
was
minor.
sent on 21st.
yes, Lord.
What was the age as per your?
As per the school also, not 16 years something has come. And according to the FI, it's 14 and a half years.
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and accept the statement of the victim in the FIR and her evidence recorded before the learning court. There is no corroborative material against the petitioner. He has also submitted that even the FSL report is awaited. He submits that out of 7 witnesses, 2 witnesses have been examined. The learned counsel further submits that as per the FIR, the victim was going to mother's side, but the document in connection with her age has been obtained from another school,
Gramin Public School Jharkhand.
from Adarsh Gramin Public School. It shows that she was minor on the date of this. The learned counsel for the state has opposed the prayer and has submitted that the victim during the trial has supported the prosecution case and the victim was minor. She was studying in madrasa as well as the concerned school, and she was enrolled in the concerned school.
It is never come in the position that she was a student of
That's right.
others public.
After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner and the victim being minor, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure that the remaining witnesses are promptly produced before the court. And the FSL branch is also directed to ensure that the examination report of the sample sent to FSL Ranchi be promptly sent to the concerned court, as it appears to be an important evidence. That this order be from the state directed to communicate this order to FSL Ranchi, SP of the concerned district, and also to the director of prosecution. That will be sufficient.
Item 6, BA 4228 of 2026.
Is aged around 53 years, he has stated, and the petitioner who is 28 years. There is delay of 6 days in lodging the and there is no corroborative evidence not supporting the prosecution case. She has said that on the date of occurrence, the petitioner has given her lift, and thereafter on the way she has been damaged, but neither medical nor, and it is said that her photographs has been made viral. Neither charge sheet has been submitted under IT Act law of 67 or any that supporting the
When was the charge sheet submitted?
charge sheet has been submitted, has come, charge also has been framed, under section 364(1) and 351. Neither under IT Act it has not been done, and there is no. And see, after 6 days, it is said that the petitioner has gone to along with his wife to bring her from Sultanganj. उसके बाद सुल्तानगंज से लाए और बोले कि थाना नहीं जाना, then case has been lost. It is said. It is a very concocted story developed. Is the petitioner is less than around 20 years younger, more than 20 years younger to the victim. Actually, she is selling mahua liquor. There was dispute with regard to payment, not in that. She is a veteran mahua liquor seller in the area.
She has been medically examined.
Yeah,
What is an FIR?
दिनांक 26/6/25 समय 5 बजे दिन में करीब हम घर से रिकिया हाट में आकर अपना घर जाने के लिए ऑटो का इंतजार कर रहे थे। इतने में कंप्यूटर यादव स्वयं रिकिया देवघर बाइक मेरे पास आया, बोला घर जाओगे तो चलो हम ले जाएंगे। इतने में हम उसके साथ पर आकर बाइक में बैठ गए। इतने में वह मुझे नवोदय विद्यालय सड़क की ओर ले जाते हुए अनजान रास्ता में ले जाने लगा। उसके बाद रिखिया थाना अंतर्गत मनीडी गांव के पास सुनसान जगह पर मेरे साथ जबरन सोयंसो बनाया। मोबाइल में भी वीडियो बनाकर वायरल कर दिया। घटना का समय करीब 6 बजे, दैट इज ओवर राइटिंग ऑल्सो, बजे रात था। घर जाने पर जब मुझे पता चला कि मेरा अश्लील वीडियो कंप्यूटर यादव ने वायरल कर दिया, देयर इज नो सच,
आगे
यस कर दिया है। तब हम अपने परिवार वालों के डर से 28 तारीख को तो घर से भागकर बस में बैठकर सुल्तानगंज चले गए। कंप्यूटर यादव और उसकी पत्नी नाम पता नहीं मुझे खोजते हुए सुल्तानगंज गया और हमसे माफी मांगने लगा। बोला कि एक बार
ये क्या वही उनके घर पे गए?
हाँ?
ये वापस लेके आए मतलब?
तो उनके मतलब वो अपने मायके चली गई और उसके बाद हम अपने पत्नी के साथ उनके मायके गए। बोले कि ठीक है गलती हो गया। देयर वाज डिस्प्यूट नॉट लीकर सी से
आई जस्ट वांट टू नो, गलती हो गया तो वापस कहाँ आई?
अपना घर लेके आए यहाँ पर, जहाँ पर गांव है अपना, ससुराल में।
टीचर के घर
नहीं, अपना घर,
अपने
घर, एक ही गांव के हैं सब। और वहां लाके उसके बाद जो है बोलते हैं कि जो कि नाइदर 60 मतलब 7 में या इसी में आईटी एक्ट में कोई चार्जशीट हुआ है, ना कोई एविडेंस है, ना मेडिकली प्रूव है।
चार्जशीट का कॉपी है?
चार्जशीट का कॉपी नहीं है, बट इंप्यून ऑर्डर में आया हुआ है। चार्ज हैज बीन फ्रेम अंडर सेक्शन 64(1)
का
मिलोड पेज 14 लोअर पोर्शन में। 7 दिन के
क्या
बाद
बोलना है आपको?
डायरेक्ट
डायरेक्ट एलिगेशन है, लेकिन जिसके साथ ऐसा इंसिडेंट होगा वो उसके साथ वापस आ जाएगी।
लाने के बाद
नहीं, एक बात बताइए, किसी के साथ इतना सीरियस इंसिडेंट हो जाएगा वो उसी के साथ वापस आ जाएगी।
लाने के बाद धमकी देने के था तो
आप सिर्फ इतना बताइए, किसी के साथ इतना सीरियस इंसिडेंट होने के बाद वो उसी के साथ वापस आएगी? उसके साथ तो नहीं आएगी ना। और चार्ज तो आईटी एक्ट में फ्रेम ही नहीं हुआ है, इसीलिए वीडियो वगैरह तो कुछ रिकवर नहीं हुआ है। yes? वीडियो रिकवर होता तो आईटी एक्ट में होता ना चार्ज फ्रेम। और the learned counsel superior on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
22/12/2025.
22/12/2025 and has been falsely implicated in this case. We have submitted that as per the prosecution statement, the petitioner and the victim are known to each other. And while she was standing on the road, the petitioner had given lift to her. And it is alleged that instead of taking her back home, the petitioner had taken her to an isolated place and committed rape upon her, and also prepared a video, which the petitioner made viral. He further submits that as per the FIR, the victim had gone to Sultanganj and the petitioner and his wife brought her back to the village, and she accompanied them back to the village, and it is alleged that she was thereafter killed. The learned counsel submits that no video has been recovered, and accordingly no charge has been framed under the Information Technology Act. Charge has been framed under section 64(1), 351, legal bracket 2 of BNS on 13/2/2026. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner, and therefore he may not be invited on bail. After hearing the learned counsel for the parties and considering the fact that charge has already been framed, but no charge has been framed under the Information Technology Act, And also the fact that the victim herself has stated in the FIR that she came back to her village along with the petitioner.
At this point.
The petitioner is admitted to be black.
Item 7, DA 4230 of 2026.
earlier rejected 25/11/2025. Yes, there is place ground.
Yes.
Chartered plan, 3 witnesses have been examined. All 3 witnesses stated
3 witnesses तो उस दिन भी एग्जामिन हो गए थे फ्रेश ग्राउंड पे 3 witnesses तो उस दिन भी एग्जामिन हो गए थे उसके बाद how many witnesses have been examined?
there was direction to expedite the trial, but not a single witness has been received to report in 6 months. और witnesses बोल रहे हैं मुझे कि जो पिटिशनर है वो हैदराबाद में रहता था और किसी मायके में रहता था और जो डेड बॉडी पाया गया वो मायके में ही पाया गया। कोई आई विटनेस नहीं है, कोई सर्कमस्टेंशियल एविडेंस नहीं है, कोई रिकवरी नहीं है, कोई कन्फेशनल लीडिंग टू रिकवरी भी नहीं है, केवल सस्पिशन है। सस्पिशन से आगे कुछ नहीं। किसी ने आते हुए नहीं देखा, किसी ने जाते हुए नहीं देखा, कोई विटनेस नहीं है ऐसा जो कहे कि ये आया था, आते हुए साथ में ले जाते हुए देखी।
The learned counsel for the petition claims that the bail application of the petitioner was rejected earlier on 12/11/2025.
12/11/25
12/11/2025 in DA number 7904 of 2025. And there was a direction to expedite the trial. But as per the interim order dated 25/3/2026, no further witness has been examined. The learned counsel for the state is directed to file a counter affidavit in this case, explaining as to why the witnesses are not being produced before the court. The office is directed to produce upon and the office is directed to call for the entire audition of the learned trial court right from 12/11/2025 up to date, along with the status of the case. The trial court should also indicate the likely time to conclude the trial. Raised this case on 29th of June. Let this order be communicated.
Item 8, DA 4231 of 2026.
इसमें के दोनों बच्चा स्टूडेंट जो साथ में पढ़ा थे क्लास में और उसकी केवल था क्लास में और आया बोले कि मैं आया वो वीडियो ये केक अपना काटता जन्मदिन पे उसने एक बार उसके इसी तरह कोई एलिगेशन नहीं है इसमें जो इनका जो स्टेटमेंट जो आया बीएनएस मोबाइल 3 वर्ष
Age of the victim is 14 years.
लेकिन कुछ एलिगेशन केवल ऐसे है कि वो अपना जन्मदिन मना रहा था उस केक जो काटा सी के नाम का भी केक तो इसलिए ही एलिगेशन kindly see your receipt. Page number 20.
Photograph media, blackmail media.
नहीं वो जो FIR में इसमें जिनका जो स्टेटमेंट मुझे आया है उससे इसमें kindly दिखाया पेज नंबर 14.
Earlier he was turned out of the
And after celebrating the birthday, he entered into the house and tried to outweigh the modesty of the victim.
इनका जो बयान में जो मुझे आया तो 180 का जो सब कुछ मुझे नहीं केवल आया कि वो जो सो घर वो कोई कुछ नहीं, केवल अपना जन्मदिन पे ये केक काटा उसमें इनका भी नाम है, दोनों साथ में पढ़ते थे और पूरा
But the team has not supported the
No
case
support.
prosecution.
इसी तरह का
कहाँ है 183 का?
183 मुझे जरा सा इसको देखिए, इसमें और चीज मुझे आएगा, इसमें वजूद है और 37 में किसी तरह का वजूद नहीं, किसी तरह का वजूद नहीं। दोनों बच्चे वो जो साथ में पढ़ते थे कि क्लास में,
तो ये 183 का तो स्टेटमेंट आएगा ना,
हाँ
ये नहीं स्टेटमेंट जो रिकॉर्ड हुआ है वो चाहिए, इससे क्या चाहिए, ये डायरी में क्या रिकॉर्ड हुआ?
तो आएगा उसके बाद
BA number 4231 of Indians.
मांगा नहीं जरूर।
The learned counsel for the state is directed to file a counter-affidavit in this case. Along with two antecedent people of the petitioner, the office is directed to call for the presiding in the concerned court along with the statement of the victim recorded under section 183 BNSS. Post on 29th.
29
And also the stage of the case.
Item 9, DA 4233 of 2026.
My lord, in this case, my lord, a statement under section 183 BNSS my lord will be false. इसमें जो 496 ऑफ BNSS का केस है, इसमें वॉलंटरली साथ में गए हैं और ये भी आया हुआ है, और जो विक्टिम का एज है माय लॉर्ड वो एज पर चार्जशीट 17 साल 7 महीना 17 तक।
18 नहीं है ना?
18 नहीं, इसलिए उसको उसका स्टेटमेंट मांगा है।
उसका स्टेटमेंट देखकर क्या करेंगे?
विक्टिम
एलिगेशन देखते हैं।
हाँ, एलिगेशन है कि पहला फुसला करके साथ मैं परमिटेड टू मारो पेज नंबर 19 निवेदन पूर्वक कहना है कि मैं 40 थाना बैगाव गिरी रहने वाली 27/10/25 को समय करीब 12 दिन मेरी इतना उम्र 17 वर्ष बताया कि साइकिल बनाने पे जा रही हूँ, मेरी बेटी काफी देर से वापस नहीं है, तो हम लोग अपनी बेटी को आसपास के गांव में खोजबीन करने लगे तो पता चला कि विवेक कुमार गोस्वामी पिता बासु गोस्वामी बसवरिया जिलागिरी ने बेटी को पहला फुसला कर मेरी बेटी को उनके साथ गलत करने की नीयत से भागकर ले गया है। खोजबीन के क्रम में मैं ग्राम बहादुरपुर के ग्रामीणों से सूचना मिली कि विवेक कुमार गोस्वामी ने मेरी बेटी के साथ सर्जन करने से नियत से बहादुरपुर से जंगल में ले गया, जहां ग्रामीणों के द्वारा विवेक कुमार गोस्वामी को पकड़ लिया गया। विवेक कुमार गोस्वामी पिता बासु गोस्वामी बसवरिया देवीपुर जिलागिरी मेरी बेटी पिछले 1 वर्ष से मोबाइल से बातचीत कर रहा था। हमारे अनुपस्थिति में विवेक कुमार गोस्वामी मेरी बेटी से मिलने हमारा घर भी आ जाता था। तब विवेक कुमार गोस्वामी हमें धमकी देता था, तुम्हारी लड़की को भाग कर ले जाएंगे। इस संबंध में करीब 6 महीना पूर्व पंचायती हुआ था, जिसमें विवेक कुमार की मां
The counsel for the state is directed to file a counter-affidavit in this case. With the case diary along with the statement of the victim recorded under section 183 BNSS we call back in the concerned court. Who's this case on? Along with the stage of the case.
Item 10, DA 4240 of 2026.
In this case, the FIR has been lodged under section 80 circular of DNS. And the petitioner is the mother-in-law of the deceased. And as per allegation, there is general and omnibus allegation attributed against all the accused persons. And at the time of occurrence in lordship, it has come in the charge sheet that the deceased was talking with her husband. And at the time of occurrence, only this petitioner was present at the court. And there is no injury or found over the body of the deceased, and there is no visceral reporting yet come and the charge sheet has been submitted.
The learned counsel for the state is directed to file a counter-affidavit in this case. Let the FSL report may and also produce a copy of the FSL report from the concerned laboratory in sealed cover for this court. Let the case diary along with postmortem report be called for from the concerned court. Post on 6th of June.
Item 11, BA 4976 of 2026.
Mayor. The office in section initially we are registered under section 37 of the BNS and section 5, 1582 and 61 of the box. They are charge frame under section 64 to subclause M of BNS and section 6 read with 5L and section 6 read with 5J2 of the box.
The child was recovered from Tamil Nadu.
Yes, sir. So, for says going to working without the petitioner.
Along with 3 girls.
Yes, along with three girls. And after recovery, during medical test, she is pregnant for 9 months. After that, 1 month, she gave birth to male child. And during investigation, she disclosed that she has a love affair with this petition.
Victim was minor.
She is 16 years, 2 years, and also the petitioner is also 17. And one thing was it 1 year delay is also she is also not satisfied with the relationship, so they filed the case initially. 2024, the FIR filed after the birth of the child, 2025. And
This
also
is delay of
the-
1 year.
after. It is the statement of the victim in FI prior to 1 year. I am in love with the petitioner. And also, the last in this case, the medical report also suggests that in para 16 of the article, affidavit,
Or the learning council appealing on behalf of the parties. The learning council for the petition submits that the petitioner who is 18 years of age is said to be in love with the victim, aged 16 years, and she gave birth to a child, and also stated that he was in love with the petitioner. He submits that the victim along with 3 other girls were recovered from Tamil Nadu. The learning council for the state has opposed the prayer and has submitted that as per the statement of victim. She has stated that she was in love with the petitioner, but the petitioner had forcefully established physical relationship with her several times. And subsequently, the petitioner stopped responding to the call. Considering the fact that the victim is minor and she has made direct allegation against the petitioner, this court is not inclined to embarrass the petitioner on bail.
Also charge framed and
Yes, sir.
also the victim is examined, already examined.
That is sufficient.
DNA profile of the child and still pending.
So far as the DNA profile of the child and the petition is concerned, the same is still available. The council for the state is directed to ensure that the required report in connection with the DNA profile of the accused and the child of the victim is forwarded to the court promptly. And the other witnesses are also promptly produced before the court. Let this order be communicated to the facility branches and also to the SP of the concerned district and director of
Under heading for admission, item 12, BA 1035 of 2026.
Especially for that one.
Letter was sent.
Have they responded to your letter?
My lord, last letter was sent 6/5/26, my lord. I talked to related, but not taken comment.
What is the allegation against them?
Allegation, is unknown, and the petitioner has been arrested in this case on basis of suspicious account. There was some quarrel between Devar and Bhavi, and confession has been taken. One lathi has been recovered. Which was sent to
From
the
where?
resort.
From where this weapon has been recovered?
House recovery, right?
On the basis of your confession, sir?
Lathi is usually found in every house. Therefore,
But that's
FSR
completely
report is very important to me.
para of the case diary. On confession of this petitioner, my lord, उनकी कपड़ा बराबर कपड़ा के हम लोग के पास स्पेस शर्ट बटन के नीचे फटा शर्ट के बाएं और पॉकेट में बाएं टू जैसा था।
Therefore, FSR report is very important to me.
घटना पे कुछ भी पर बताई कि ये घटना किसने यही फैमिली में घर से बरामद किया गया। That's come in para 51 of the case.
The learned counsel for the state has submitted that. The deficient report has not yet been received. The counsel for the petition submits that the petitioner is in custody since
28 June 2025.
28
June 2025.
2000. The petitioner is in custody since 28/6/2025. And there is no eyewitness to the occurrence. He has been falsely implicated in this case. He has admitted that as of now, there is no material to connect the petitioner with the alleged offence. The FSC report has also not yet been received. The learned counsel for the state has opposed the prayer and has submitted that the victim was found dead with some clothes in her mouth, and the weapon used to murder the victim has been recovered on the basis of confession statement of the petitioner. And blood-stained shirt was also recovered on his confession statement, which appeared to be blood. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the FSL report is still awaited. The petitioner is directed to be enlarged on bail. However, the FSL Ranchi is directed to ensure that the FSL report be promptly forwarded to the state concerned. The council for the state is directed to communicate this order to FSL Ranchi to ensure compliance.
Item 13, DA 2147 of 2026.
Last occasion is there in accident response for case under section 87 of the BNS. Now the both victim and the petitioner were working in Ashley Pius Wellness Private Limited. He was the manager of it. There they got friendly and then they got married also. Subsequently,
Case where the petitioner had disclosed a different religion of
religion issue has come.
religion issue has come. He has disclosed himself of a particular religion and subsequently he was found to be of another religion. And
He was the man. Unless the ID card, she was working there. That same.
no,
same
they
is the
were
ID
working,
card.
there is no doubt on that.
Correct.
But religion is a very important angle in society.
But that
So
religion,
that's why she has
was
said
aware.
that
She was aware of the fact. Let
no,
us
she
see
was not aware,
some of the.
as it appears from her statement.
उसका नाम ही वही था. I just try. What she has, what all admissions are there, Manoj? I just try to show you.
Show me the FIR first.
Yes, let us
Read
see.
the FIR.
Yes. FIR is at least 13.
पढ़ी?
निवेदन पूर्वक करना कि मैं रेणु देवी उम्र 42 वर्ष पति 1612 मध्य दरबार में विराजमान करें आज दिनांक इतना को आरिफ हुसैन उर्फ आरिफ खान मेरी पुत्री प्रगति कुमारी 19 वर्ष 50,000 रुपया नकद तथा 2 लाख रुपए के जेवर के साथ देकर भाग गया. महाशय से निवेदन है कि विषय पर प्राथमिकी उचित कार्रवाई कर मेरी पुत्री को वापस लाने की कृपा करें.
And where is the statement of the victim?
Now, then, a writ application was preferred, wherein a report was called for, and the report is annexed to at page 14. That report shows what exactly happened, how they both wanted to surrender, and how they both wanted to get themselves
Read the
registered.
report.
Look, Prasangit Vidya Sahasrara card to lordship is at page 14 minutes.
I'm at
सभी थाना आधार पर पुत्री प्रगति कुमार नगर जेवर भाग ले जाने के आरोप का दर्ज कराया है. कांड का अनुसंधान भार सुदामा नगर स्कूल के अनुसंधान क्रम एवं प्रकाशमाई कांड के अभियुक्त मोहम्मद आरिफ हुसैन 1600 मंदिर के पास जिला नेटवर्क कुटकी में जिला नेटवर्किंग का काम करते धनबाद क्षेत्र में MWPL जिस कंपनी का मुख्यालय दिल्ली में है में एरिया मैनेजर. अब अपहृता प्रगति कुमारी की माता रेणु प्रिंस प्यारे तथा सुनील सभी उसी नेटवर्क मार्केटिंग में साथ काम करते हैं। इसी क्रम में आरिफ खान प्रलोभन देकर प्रगति कुमारी को अपने प्रेम जाल में फंसा लिया और आसनसोल मस्जिद में गुप्त रूप से उससे प्रेम विवाह कर लिया। दिनांक 2/5/25 को प्रगति कुमारी कागजात बनवाने के नाम पे धनबाद आई और मोहम्मद आरिफ खान से कोर्ट मैरिज करने का प्रयास करने की मामला खुल जाने पर प्रगति कुमारी और आरिफ खान दोनों धनबाद से भाग गए। अनुसंधान के क्रम में ये बात प्रकाश में आई कि आरिफ खान परिवर्तित मुस्लिम है। स्कूल में मुकेश रजक नाम जिला धनबाद इस्लाम धर्म कबूल करने के बाद अनिशा खातून नामक लड़की से शादी किया था, जिससे पुत्र अब्दुल रहमान तथा एक पुत्री है। मामले की गंभीरता को देखते हुए थाना प्रभारी अनुसंधान के क्रम में सीसीटीवी कैमरे का अवलोकन किया। अपहृत प्रगति कुमारी का मोबाइल संख्या 1600 है। आरिफ खान का मोबाइल संख्या का सीडीआर प्राप्त किया। टावर इंफॉर्मेशन के आधार पर बंगाल में पीड़िता की बरामदगी और अभियुक्त की गिरफ्तारी छापेमारी सफलता नहीं। इसके पश्चात पीड़िता इंस्टाग्राम उपयोग करती थी। मदर जी 1600 आसनसोल में छापेमारी कर सकते। अनुसंधान के क्रम में संदिग्ध वकील पम्मी खान, नौकरी वकील सत्येंद्र पंडित अहमद से पूछताछ किया, परंतु कोई उल्लेखनीय सूचना प्राप्त नहीं हो सकी। अनुसंधान बैंक खाता पैसा निकासी पर रोक लगा दिया गया। पीड़ित का व्हाट्सएप मैसेज आईपी एड्रेस प्राप्त करने का प्रचार किया गया। आवेदन प्राप्त किया, पुनः प्रचार किया गया। The annexure 3 is his.
There is her statement.
The photograph.
No,
Her
her
statement
statement.
I cannot. We cannot.
It's there in the case diary. You have the case diary?
He's in custody for nearly 1 year. Nearly 1 year.
Yes.
And the photographs of her entire family working in the same company.
No, that is there.
There is one
But the
more
point is that what is her statement?
There is one more statement of the advocate, which is an extra 5 minutes.
Detail का statement आपने
ठीक है, जो statement है आप पढ़ लिए उसमें
आपने पढ़
उसको कुछ नहीं करना है। And she has appeared also.
क्या बोलना है? You are for the informant, the victim.
I'm for victim.
For the victim.
Victim को ही notice जाता है।
आपको क्या बोलना है?
लॉर्डशिप मुझे बताया गया था कि मुकेश नाम से इंट्रोड्यूस हुआ था मुझसे और बाद में पता चला कि ये मुस्लिम है और अनमैरिड बताया। मेरे उम्र की बेटी है जो कि इस एफिडेविट में वो पैर वही बनी है। मेरे उम्र की बेटी है, उससे बड़ा बेटा है इनका और ये सारी बातें मुझे नहीं बताया था।
For the learning council opinion on behalf of the parties, the learning council for the petitioner summons that the petitioner has been falsely implicated in this case, and the petitioner as well as the victim were working together in a company, and there was love affair between them, and ultimately they also got married in masjid. वो document है masjid का? लगाएं? They also got married in masjid.
लॉर्डशिप शादी नहीं हुई है।
Just please hold. इन्होंने बताया है, पढ़ा है तो लिखना चाहिए. And thereafter the petitioner has been falsely implicated in this case. The learned counsel has submitted that as per the FIR itself, the petitioner and the victim had run away with 50,000 cash and jewelry from the house. The learned counsel appearing on behalf of the victim has opposed the prayer for bail and has submitted that the petitioner had introduced himself as Mukesh Kumar and also told the victim that he was battling, but subsequently and established physical relationship with the petitioner in the pretext of marriage. But subsequently, the caste of the religion of the petitioner was found to be different and was found to be already married. It has been, the statement of the victim has been recorded in the case diary at line 87. After hearing the learned counsel for the parties and considering the nature of allegation and the false disclosures made by the petitioner to establish the physical relationship with the petitioner, that this court is not inclined to enlarge the petitioner on bail constitution.
Item 14, BA 24223 of 2026, along with item 15 to 17.
Oh, sorry. Is the, I'm sorry, but in this case, the antecedent clearly it has not been mentioned because we come up with 15 antecedents. The person has got 15 antecedents. Now they have not come up with an affidavit as to how many antecedents he has. In the last date also the same thing.
But there are several cases. In some cases, they have been acquitted.
In some cases, I am not accused because I am a man of antecedent. I take that. I have
They
various
can
cases.
take it, that's
I
what-
yes, I am saying that.
Then we will see the nature of
Yes, the allegation.
allegation.
No, my custody I completed 6 months. I think for antecedent that's important enough apart from the allegations. Page 24.
Yes. Page 24.
Yes, the type the सेवा में थाना प्रभारी सेवा चालू जिला रांची विषय प्राथमिकी दर्ज करने के संबंध में महाशय निर्देश तो कहना है कि मैं सिराजुद्दीन अंसारी हिंदू परिलिखना पिता स्वर्गीय स्वयंसो प्राण स्वयंसो चालू जिला रांची का रहने वाला हूँ आपराधिक प्रवृत्ति के सभी फंडे पिटिशनर आयुक्त पिता स्वर्गीय स्वयंसो प्राण स्वयंसो चालू जिला रांची अपने सहयोगी नसीम पिता स्वयंसो इजाउल अंसारी पिता स्वयंसो रशीद अंसारी पिता स्वयंसो सभी ग्राम बलसोपरा थाना चालू जिला रांची इम्तियाज आलम पिता स्वयंसो राम लाहौर थाना कुल्लू जिला लोहरदगा के साथ चालू थाना क्षेत्र के साथ अन्य जगहों पे जमीन की खरीद बिक्री करते हैं इन लोगों के द्वारा खरीद को अपने आतंक का भय दिखाकर जबरन जमीन पर कब्जा कर लेते हैं इन लोगों की आतंक के भय से कुछ लोग नहीं बोलते जो कोई व्यक्ति इन लोगों के खिलाफ आवाज उठाता है उसके विरुद्ध हथियार डालकर यह अन्य झूठा केस में फंसा देता है इन लोगों के आतंक से मेरा पुत्र सद्दाम अंसारी ने अपने गांव के दोस्त मुखबिर परवेज बाबर अहमद अंसारी रागिब अकरम इजार अंसारी के साथ मिलकर उस तरीके से सबीर खान है उनके सहयोगी के विरुद्ध NIA ATS थाना के अन्य जगहों पे आवेदन दिए हैं इस घटना के बारे में सबीर खान को मालूम हो गया जिस पर सबीर खान ने मेरे बेटे सद्दाम के साथ उनके दोस्तों को धमकी दिया कि तुम लोग आवेदन वापस ले लो नहीं तो कोई गलत केस में फंसा देंगे तुम लोग अपने अभी हमको नहीं तुम लोग अभी हमको नहीं जाना है प्रशासन मेरे पॉकेट में रहता है मेरे बेटे बोले कि सबीर खान की धमकी के दबाव के बावजूद आवेदन वापस नहीं पाए तो उपरोक्त पांचों लड़का के विरुद्ध सबीर खान ने स्वयं पिता स्वयं रांची जेपी रांची थाना कोतवाली जिला रांची के साथ मिलकर आपराधिक योजना बनाकर वीडियो थाना में झूठा केस बलात्कार करवा दिया जिस पर मेरा बेटा सद्दाम वर्तमान में जेल में बंद है दिनांक 1/10/2025 को आकिब करम के बड़े भाई आकिब अकरम पिता स्वयंसो ने बताया कि बीती रात से वीडियो थाना प्रशासन ने पर छापामारी के बाद सबीर खान नंबर 2 नसीम अहमद नंबर 3 इजाउल रहमान नंबर 4 इम्तियाज आलम स्वयंसो थाना पुलिस जिला लोहरदगा मेरे घर में घुसाया और मां बहन लड़ाकर गंदा गाली गलौज कर रहा था तथा मेरी पत्नी स्वयंसो को गाली देते हुए मना कर दे तो सबीर खान ने उसको बेइज्जत करने की नीयत से उसके टीचर जमीन में गिरा दिया जिससे वो लज्जित होकर रोने लगे हम किसी तरह इन लोगों को हाथ पैर जोड़े और वे लोग वहां चले गए धमकी दिए कि घटना के बारे में थाना में बताया तो बहुत बुरा अंजाम होगा हम इस धमकी से काफी डरे दिनांक 3/12/2025 को माननीय न्यायालय रांची में मेरा बेटा सद्दाम की जमानत की सुनवाई थी जिस पर किसी कारण से मेरा बेटा जमानत पर शुक्र इसके बाद मेरा बेटा सबीर अंसारी ने बताया कि जवेद रहमान मदरसा चौक लाहौर रोड के पास हमें देखकर धमकाते हुए कहा है कि हमें सबीर खान भेजा है और बोला कि तुम लोग अपने भाई को जेल से बाहर निकालना चाहते हो। सबीर खान के पास सब कोई मिलकर 10 लाख रुपए पहुंचा दो। तब तबस्सुम सबीर का पैर पकड़कर माफी मांग ली तो सब ठीक हो जाएगा। नहीं तो अभी जो ट्रेडर है दूसरा पार्ट में 5 लोग तथा तीसरी पार्ट में बाकी लोग को ऐसा ही केस में भेजना है। तो आपके वक्ता ने बताया कि दिनांक 5/12/25 को करीब समय 1 बजे दिन को लाहौर स्कूल के पास सबीर खान का अपनी इम्तियाज पिता सोनसो राम लाहौर में विकी खान सोनसो आला अंसारी ग्राम सोनसो आया और इम्तियाज आलम ने पिस्टल ताकते हुए बोलने लगा कि तुम बहुत बड़ा बॉस बन गया है। तुम लोग अभी तक सबीर खान का पैसा नहीं पहुंचाया है और पिस्टल उसके कनपट्टी में सटा दिया और विकी खान जबरन रमजानी पूर्वक
You are in custody since when?
I am in custody since December, 30th of December, 6 months almost. So there are two parts of extortion. One is under section 3085, that is implicating in a false case. And one is putting them in a fear of death, which I see is that. But the money has not. It is only in order to commit extortion that this was there. Ultimately, what happened, the case resulted in the submission of a FRT against them. There's a protest pending. So to say that I had
FRT has been submitted
against the son of the informant, saying that the case was not true, but the informant I told has filed, the victim has filed a protest which is pending. So that is a completely different path. Now to connect that case with me and then to take it forward, it also appears that there was some enmity between
FRT was submitted when?
FRT against the son was submitted. I just checked. But I was told that FRT has been submitted. That's what counter there, sir. The counter there.
FRT was submitted when?
Yes, I just
Along with the prosecution for finding a fraud.
at 8.
30th of December 2023.
30th December 30.
And this case note comes to be filed. The date of this FIR is important. It is 12th of December. Immediately thereafter, the FRT has been filed.
The protest is pending.
Protest has been filed.
What material has been collected against you?
Apart from this note, whatever is in the FIR is the reputation of
What is there in the case diary? What is there in the case diary? Has any villager come to support
No,
the
not that I am
allegation
not
that
aware.
you are otherwise an extortionist?
Yes, that notes people are saying that I am involved in other cases of extortion, hence the antecedent becomes important. That's the only thing. But in many cases, therefore, I was saying I have been acquitted. And in many of the cases, we have said I am not even accused. I have annexed the document as proof that the reference of the cases made in the counter affidavit as my antecedent. I have
They have
not.
filed a supplementary.
Yes,
affidavit.
supplementary
State
affidavit
has
of
filed
26.
an affidavit.
Sorry.
State has filed an affidavit.
Yes, it has filed. And in response to that, we have also filed an affidavit on 27. They keep showing few in cases, matters like Jagannathpur PS
That's
case.
right, but there are
Yes, there are instances.
numerous cases of
Cases.
similar nature.
Similar. That is that I cannot get over it because there are cases of that nature against me. But the fact remains, ultimately in this case, you are saying that it is a case of in order to extort, not there where the money has been transferred. And the case has been set up at 3 different levels. One, first, that there was an allegation that they made a complaint to NIA or ATS. What happened to that? There is nothing. I wanted them to withdraw, hence the false case of rape. That's the first. Then they say in order to settle that false case of rape, I demanded 10 lakh rupees. And then they third, they say they have not come to terms. Well, again, they just went and put someone else, not me. I have not gone and put any revolver or anyone's temper, but there are my people have gone. It is not that much. They are also not. They also probably have antecedents. All these groups, they are involved in this purchase of land. So I know there is some murky business going on between both the parties. That's a fact. Let us not hide our faces from it. Apart from so far as this case is concerned, I don't think that whatever is in the FIR more.
Yes.
But now the disclosure, the confession becomes very important. As to the manner in which the
Whose confession?
confession of all of them, his confession, the girl's confession. So I'll read the girl's confession, what she has to say as to how they falsely implicated, how they all managed it, stage managed it, where she was taken, and then how, since how that becomes very important.
The victim of the rape case.
Yes.
Okay, now that particular FRT has been submitted in the
FRT submitted.
Your protest is pending.
No, that FRT, therein the police has also mentioned that there needs to be a prosecution against him for filing a false case. It's not a simple case of FIT. It has been found that yes, that proves my case that this false case was done. This racket was there in order to extort. See, how can you lodge a false rape case against a person? Now, how it was lodged, that statement becomes very important, but that leads to a disclosure of a fact. So I'm reading the confession of that person. And then if your lordship permits me, I read his confession also. That confession is there in the case diary. Page number 12.
His case is, as per the FIR, if you understand it better, that there was a rape case against the accused of the case, of this case.
Yes. Son of
the accused of this case.
Yes.
Son of the informant.
Son of the informant.
Son of the informant.
Yes,
of
son of the
The
yes.
victim is also an accused in this case. She is also in custody.
Okay.
Now, the son of the informant was falsely implicated by one of the accused, who is before my lords. Now, they falsely implicated him, his son, in a rape case. Now, when this matter was properly investigated, it was found that this is a racket going on. It's an organized racket. See, where the policeman is also involved, the person who had got the case lodged. Now, the girl, this man who has antecedents. Now, how the manner in which how he has created terror in the village. All these factors. I'll read it. Now, the statement of the witnesses who have said that yes, he is man of such nature. Now, why this becomes very important so far as he is concerned? Now, he is manipulating the very criminal justice system. Now, let me read the confession of the girl. She has given in detail as to how she implicated at the behest of this person.
Where is that?
That is there in the case diary. Page 12, Manoj, page 12, internal page 12 of the case diary. It is para 29 onwards. Now, on the
So
last.
she has confessed that it was a false case.
No. The manner in which she lodged the case.
Yes, the manner in which.
How he was involved, how they jointly did this, and how serious it is. Now, on the last occasion, I had mentioned that the girl has previously also done the same thing with another person, wherein she said that she compromised it.
That's
So I'm just reading the confession, or the confession.
right.
बट बयान में देती हूँ कि मेरे विरुद्ध माननीय न्यायाधीश प्रस्तुत किया गया और कॉमर्स इंटर की पढ़ाई करनी पड़ेगी। मेरा बयान एक बेड़ो कांड संख्या 1 दर्ज करने के 2-3 दिन पूर्व नसीम अंसारी द्वारा सबीर खान से मिलवाया गया। पल्स रेस्टोरेंट किला चौक में जहां एक झूठा रेप करने के केस करने के लिए हम लोग के बीच मशवरा हुआ, तय किया गया। बेड़ो थाना में चलकर पांचों अभियुक्त सदाम अंसारी, रकीब अंसारी, जहार अंसारी, मोबीर अंसारी सोनसू जिला के रहने वाले हैं। उनके विरुद्ध झूठा रेप कर केस करवाने के बदले मुझे साबिर के द्वारा लगभग 50,000 रुपया देने की बात कही गई। दिनांक 2/9/25 को नसीम अहमद सोनसू रांची में मुझे लेकर बेड़ो के थाना निकले। करीब 12:15-30 बजे हम लोग नगरी पहुंचे। योजना अनुसार मेरे मोबाइल को स्विच ऑफ कर दिया गया। समय 17:30 बजे आसपास बेड़ो मोड़ जहाँ सबीर खान सोनसू जिला के इस रोड पे आए और हम लोग से मिले। उसके बाद सभी लोग
only submission reported to the confession statement, the girl has filed a protest petition. Now to say that whether the confession is voluntary or involuntary, anyways the confession statement is no value. But just for the purpose of bail also, she is also called and filed a protest petition which is pending. This is a case where the girl may be true, maybe not be true, that's for the courts. Now to say, use a word that I have, the criminal justice administration is in my hands, is too broad a statement to bring anyone. Then the details are to be given who are
And
those.
his conduct was also very important in the court. Now, the moment he had a case in Silly, now he concealed it. When we came up, we showed that, look here, first he said there was only 7 contestants, then came 10, then came 12, then came 15.
For the learned council's opinion, subcommittee is common or different?
No, no, she lost the facts are different.
Facts are different, Your Lordship.
Just,
We are only asking for something.
you are for Sabir only? For the learned council's opinion on behalf of the petitioner, ये है BA number 2423 of 26. The learned council for the petitioner has submitted, has placed the FIR and has submitted that as per the FIR, the certain complaints were lodged with NIA/ATS and others, and the petitioner threatened the informant to withdraw the complaints. Withdraw the complaints made by the informant's son, and also claimed that he is a very influential person. But when they refused, Sabir Khan, in conspiracy with the woman, lodged a false rape case at Beirut PS, as a result of which the informant's son, Saddam Ansari, was in judicial custody. The accused further alleged that the accused further allegedly trespassed into the informant's house, abused his family members, outraged the modesty of his wife, and demanded extortion money for securing the release of the son of the informant, and committed extortion at the gunpoint, and also continuously threatened dire consequences. It has been alleged that the petitioner and other accused persons are involved in sale purchase of land, and they are also involved in illegally grabbing the land of the villagers, and villagers are under constant threat of the petitioners. The learned council has submitted that so far as the rape case against the son of the informant is concerned, a party has been submitted and the victim has lodged a protest petition which is pending consideration. The learned council submits that so far as the antecedents of the petitioner is concerned, he has a few cases against him, but the same may not be a ground to refuse the bail in the present case. The petitioner is in custody since 13/12/20. The learned counsel for the informant, are you the informant?
Yes.
Informant has, as well as the state, has opposed the prayer for bail and has submitted that the statement of the victim of the rape case has also been recorded in the case diary, and she is also a co-accused in the present case. And as per her statement, she had lodged false case at the instance of the other accused of the present case, and had also taken money for the same. He has also submitted that the criminal antecedents of the petitioner reveal that he is involved in a number of cases involving extortion.
And the FRT shows that he has been, there is an application for against him by the police for false implication.
The FRT submitted in the rape case also shows that the police has also suggested for
prosecution under section
section
217 and 248 of the
217 and 248 of the BNS.
Yes.
To this, the learned counsel for the petitioner has submitted that the very fact that she has filed a protest petition is conflicting to her statement recorded in the case diary. Confession statement recorded in the case diary. After hearing the learned counsel for the parties and considering the nature of allegation which involves according to which the petitioner is involved in organized crime and there are numerous cases of similar nature pending against the petitioner. This court is not inclined to enlarge the petition on this. Yes, who is for the other questions?
Item 15. DA 09.06.2026.
Yes, petition.
Yes, Roshan, my name has been transferred in two places in the file in the first page and the second page as an associate. It has been disclosed as associate of Sabir Khan. Firstly, in the fifth line, आपराधिक प्रवृत्ति के साबिर खान, page number 11 of the bill application.
आपका क्या नाम है? What is the name? What is the name?
Naseem Ahmed.
Naseem Ahmed. Yes.
आपराधिक प्रवृत्ति के साबिर खान पिता सबीर खान ग्राम बलसोकरा थाना चानो जिला रांची अपने सहयोगी साबिर अहमद अंसारी एक जगह मेरा यहाँ पे नाम आया रोशन पर कोई स्पेसिफिक एलिगेशन पूरे फाइल में मेरे अगेंस्ट पे नहीं है एंड उसके बाद एक जगह और मेरा नाम आया रोशन वो भी एज एन एसोसिएट ही आया है रोशन
You all entered into the house.
Yes, but no specific allegation has been alleged against me कि I have touched है वो सारा जितना भी है बस साबिर खान का नाम ली है और मेरा नाम कहीं नहीं सिर्फ साथ में हम आए थे no specific allegation has been made against me lordships and यहाँ जो एक लाइन है lordship second page of the FIR है वो खुद FIR नहीं कर रहे हैं जिनकी वाइफ के साथ हुआ है वो इनको बताए एंड शी इज अलेजिंग द सेम ये यहाँ पे द एलिगेशंस वो इन्फॉर्मेंट जो बता रही है उनको वो बताएगा
इन्फॉर्मेंट तो जो विक्टिम है उसके हस्बैंड ही है ना उनके घर वाले हैं
लॉर्डशिप्स यहाँ पे हम वो बताएंगे लॉर्डशिप्स
that's right that the incident happened in their presence only one
लेकिन मेरा बस एक ही एंटीसीडेंट है दो एंटीसीडेंट बताया गया है मेरा बस एक ही एंटीसीडेंट है एक में मेरा एक्विटल हो गया है काउंटर एक्विटल में आया है कि मेरा दो एंटीसीडेंट है उसमें से एक में मेरा एक्विटल
आप जिसमें एंटीसीडेंट है उसमें जो केस में आपका एंटीसीडेंट है उसमें सबीर खान इज आल्सो एक्यूज्ड कौन सा एंटीसीडेंट है
Lordship, page number 9, annexure B of the counter affidavit, Lordship. जिसमें से एक में
9 annexure B, right? चानो केस नंबर 179.
Yes.
और ये कौन सा केस है चानो केस नंबर? 181 है, ठीक है? You are in चानो केस नंबर 179.
Yes. That is the one.
सबीर के अगेंस्ट पे भी चानो केस नंबर 179 है. Tell me, you must be knowing. है उसके पास ये है
So you know, इसमें मेरे against तो कोई specific allegation लगाई है.
specific allegation नहीं है, but you had accompanied him along with
I
others.
have remained in custody for 6 months, and I was just accompanying him, and I don't have so much of antecedents, only one antecedent, and that has also not been proved yet, that is pending against me,
He is also part of 170.
Yes, they are all co-accused in 170.
In only one case,
308 is what section? 308 is what BNS is. BNS दिखाई.
Extortion was by putting a person in fear of death. Corresponding to
Extortion का ही है ना?
386.
Yes, extortion का है, but what allegations have been made in that case? ऐसी false implicate उसमें भी क्यों? सिर्फ एक ही case again, दो case थे जिसमें से acquittal हो गया, एक में मेरा and ये भी एक pending है जिसमें अभी तक मेरे against कोई proof नहीं हुआ है और इसमें भी कोई ऐसा specific allegation कि हम कोई act किए. I was just
you being accompanying the accused person to commit the offence.
And for that, have remained.
अकेले जाकर extortion.
And I have remained in
what is the punishment prescribed for this kind of offence?
Which section,
308.
Maximum, 7 years. So maximum punishment is 7 years.
5 भी है, 308 5 भी है, which is 10 years. Right?
मैंने कोई threatening नहीं दिया, allegation नहीं, बस I was just accompanying him, and I have one antecedent, and to confession statement है, that lady, that is a confession statement which was given under the pressure of the police. She has given that confession to the police in custody.
Yes, what do you have to say to this?
Part of the same group, that's what she says. The same extortion group. That's it. He had accompanied, he was also there all throughout, active member of the same gang.
She had taken at least 20 times names of Sabir Khan, but my name only 2 times. No allegation, just I was standing there. No allegation, and for that standing, I have remained in custody.
People are under fear because of you, because of your gang.
I was carrying a weapon.
People are under fear because of your gang, so you wait for something.
I've done nothing, just accompanying you.
You are an extortionist, and there is an antecedent. With Sabir Khan, one is enough.
In that case also,
you are an associate of Sabir Khan. This cannot be denied.
But I'm not.
That is why I was looking whether you are an accused in the same case or not.
Sure, but I've not done any act in that case also. That has also not been proved yet. That is pending against me. Though charge sheet has been submitted against me. But till later, that case has been proved against me. That will be counted as antecedent, but
this was the complaint which they started at his house here. With the entire village signing.
For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioners has submitted that though the petitioner is named in the FIR, but except the fact that the petitioner was accompanied with Sabir Khan and other co-accused, there is no overt act against the petitioner. The learned counsel submits that.
One more thing, maybe one similarly situated co-accused, वो भी बस associate थे, उनका bail हुआ Annexure 2 हम लगाए हैं, बस वो भी एक बार देख लेते.
The learned counsel has also submitted that one similarly situated co-accused, namely
Anim Ansari alias Vicky Khan.
Anim Ansari alias Vicky Khan.
He was also accompanying.
Has been enlarged on bail. Wide order dated. The wide order dated इतना गुस्से में देखने की जरूरत
बस वो बोले no criminal antecedent some
नहीं। बताइए कहाँ है आपका ऑर्डर दिखाइए।
Here the page number 26 annexure 2
पेज नंबर 26
annexure 2. A fact has also been considered that there was delay of 9 days here in that case annexure 2.
पेज नंबर 26 has been enlarged on bail. Anim Ansari alias Vicky Khan has been enlarged on bail in BA number 1984 of 2026. The learned counsel for the opposite party has submitted that the case of the petitioner has opposed the prayer for bail and has submitted that in another case, the present petitioner is accused with Sabir Khan, which in Chano PS case number 179 of 2025, which reveals that the petitioner is an associate of Sabir Khan in the matter of extortion and other related offence. And it has been alleged that the people in the locality are under constant threat from the entire gang of persons who are accused in the present case. So far as the bail of the co-accused is concerned, he submits that the antecedent report and the presiding was not called for in the same case.
He had been considered, not mentioned, so I could not say.
That's right. Second order number 2 है next day ना presiding हुआ होगा ना encounter हुआ होगा.
State cures for confinement.
किसमें?
अब फाइल इस सब में
अब ना फाइल है. वो जो जिनको कोई accused का bail है उसमें तो नहीं हुआ. The learned counsel for the state has also opposed the prayer for bail and has referred and has supported the submissions made by the learned counsel for the informant in this case. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the petitioner of accompanying Sabir Khan in the alleged commission of offence, and the criminal antecedent of the petitioner reveals that the petitioner has been committing the offence along a similar offence along with Sabir Khan, and therefore the bail application of Sabir Khan having been rejected, this court is not inclined to enlarge the petitioner on bail.
Item 16, DT.09.06.2026 of 126.
The allegations plus as has been referred in the previous bill applications because it is almost the same. Here also he is an associate because having one antecedent, same 179 because he was accompanied.
Same order.
Same.
Same order.
Counter में उन्होंने 179
and 34 of 20 also.
34 of 20. इसमें 2 criminal antecedents हैं, counter affidavit में देखेंगे. 34 of 20. 34 of 20 में सभी भी है कोई है क्या? लाइब्रेरी सभी. उसमें है ना चालू पीएस केस 34 of
34. हाँ ये है. ये
Any other cases there?
Yes, item 17, DA 3486 of 2026.
इनका क्या है? ये कौन है? इम्तियाज.
Because she was the lady because who made the complaint because regarding the rape having been committed because and she has been the entire submissions of this lady has been recorded by my lords only. In the order dated because citing 29/4/2026. The order number 5 is
This is the bail application of that lady.
the lady. Because the allegation with respect to this lady is that, that she was set up by Sabir Khan for falsely implicating. Because while making the advancing the submission, the learned counsel for the informant had advanced a submission that in another case also because I had made a similar allegation with respect to that is I suppose with respect to Khelgaon PS case number 86 of 2024. 86 of 2024 because the FIR is there. It is all it is only only on different contexts. It is not related to that was the case because I got the certified copy of the FIR also to that extent. Because frankly there is no demand nothing to that extent.
She is not accompanying anybody.
No, there is no allegation with respect to that I was accompanying. The only case which I had lost prior to this was 86 but that was in relation to the love betrayal relationship with one person who had cheated. And I am also in custody since 13/12/2025.
And you're
179 million.
She also accused 179, the same group, Sabir.
179 में आप
179 में loss will find from the FIR itself.
You are an accused in 179 also.
That is there on record.
Check कर लीजिए. काउंटर में आया है 179. इनका एक्सीडेंट रिपोर्ट आया है. एक्सीडेंट रिपोर्ट बताइए इनका.
आप क्या कौन से antecedent दिए हैं? And because it finds that allegation.
I have also yes, an order of bail wherein she compromised.
Because the compromise because I am bringing on record because the
Forget about the
FIR itself because the FIR
Where
is
is
only on a different.
where is it that she is accused in
179.
ठीक है कौन सा
बताइए. Where do I get that she is accused?
I'll just paragraph 50 minutes.
Paragraph 50 of the case that
Because so far the 179 is concerned just has got a copy of the charge sheet because the charge sheet does not disclose so the charge sheet is there. The charge sheet of 179. No, charge sheet has been submitted. 179 charge sheet.
179 charge sheet have been submitted.
Charge sheet
have been submitted.
उसमें देखिए मेरा नाम नहीं डेटी जस्ट वेरीफाई वो चार्ज शीट की कॉपी करेंगे
इसमें तो नहीं लगता.
नहीं है वो हमने वेरीफाई भी कर दिया.
She is not an accused. Yes, state है ना इसमें. Antecedent बताइए petition.
State को I not yet received the diary lordship of.
What do you mean not received the diary?
Submitted before lordship. He has stated that
आपने काउंटर फाइल किया है ना इसमें तो बिना डायरी के काउंटर फाइल कर दिए हैं. Is there any antecedent? Is there any antecedent of the petitioner?
paragraph 50 of the case diary lordship it has been mentioned. One case.
One case means
Because 179 के आपके पास 170 तो 179
179 में का वही नहीं बता
वही हमें
the state is not saying though he has at 179 में she's an accused.
पैराग्राफ इसमें देखिए
Paragraph 50 of the case that
देखो 179 इसमें तो इसमें involved है she's involved
Nasiha Khatun. Nasiha Khatun.
Yes,
But
yes.
charge sheet has not been submitted.
That we'll verify, Manoj, that because they did not file the charge sheet in the court. We'll check it out because here it is mentioned. For that only, Manoj, in that famous case in the Supreme Court, that section has been incorporated that if you have an antecedent, kindly mention the antecedent and kindly mention the status of the case.
because that is true because that true disclosure has to be made because I also because go down to his body has stated because
Have you stated that you have no
because
criminal
I have stated
antecedent?
because that I don't have an antecedent.
But that itself is a ground for.
No, because what he is submitting because there is a recent judgment also of the Supreme Court because while considering the Tiwari's judgment because as well as Ayub Khan because that says because antecedent is one of the determinative factor because it cannot be the sole determinative factor because particularly when because I have got because
Non-disclosure.
because so far the non-disclosure is concerned because the societal impact everything has to be.
Mr. Senish, you see, in this charge sheet which has been submitted, she is not an accused in this
If
case.
you not sure, gives me 2 days, we'll verify this. Because see, first they did not disclose it, but we are dealing with what kind of people? But they are the one, but the NIA report which we had said, but the entire village had said, what they are doing is, but if you want to read this, the village ka jo report, they have an office outside the police station. They lodge a case and then they ask them to come for a compromise and then money is decided. So how much money the compromise would be? Or if they have land, then they will have to part with the land. This is what he is doing. He carries along with all these people, bouncers, bodyguards. The entire village have mentioned this. That this is a gang of people. She's
Excuse me,
member of that.
Priya. The learned counsel for the state has submitted that the present petitioner is also an accused in another case bearing Jammu PS case number 179 of 2025. Dated 11/12/2025. Lodged under section 308 within bracket 4/308 within bracket 5, 352, 351 within bracket 3 and 3 within bracket 5 of BNS. He submits that the petitioner is a close associate of the other accused persons in the present case and had lodged a false case of rape. However, the counsel for the petitioner has denied this aspect.
Because the FIR is given against 6 persons because I can because Sabir Khan is there because the
Counsel
second
for the state is directed to file a supplementary affidavit in this case, bringing on record the document on the basis of which it has been recorded in paragraph 50 of the case diary that the petitioner is also an accused in Jammu PS case number 179 of 20. अब डॉक्यूमेंट लेके आइए, चार्जशीट लेके आइए, सब लेके आइए, ऐसे थोड़ी चलेगा। कब लेके आएंगे बताइए? 2 weeks इसके लिए? तब तो वो जेल में रहेगी। हाँ?
1 week में हम लोग भी देते हैं।
Next Wednesday.
एक ऑब्जर्वेशन बस प्ले कर रहे थे कि एट दिस स्टेज कहते थे लॉर्डशिप क्योंकि मेरा
सारा bail application at this stage you can file it every day. Next Wednesday.
Item 18, BA 3131 of 2026.
Yes, please.
This case was called for
counter affidavit has been filed. This is the case not registered under section 103.
You had withdrawn the case earlier.
Earlier, not I had withdrawn it. I have mentioned this in paragraph number 2.
You had withdrawn on 63/26 and again filed on 26/3/26.
For charge
चार्ज के अंदर समझ में नहीं आया इसलिए आप बताइए.
But the allegation is that on 30/10/2025, not at about 8 a.m. Not informant who happens to be the son of the deceased. Not he received information that his father has been murdered by someone. Not he reached Ranchi at the place of occurrence, and some of the villagers, the name of whose are not mentioned in the FIR, told him that few days before the occurrence, there was some kind of a scuffle in between this petitioner and the father of the informant, and because that scuffle had taken place, therefore the informant had put a suspicion that the petitioner might have murdered him. Now, but since the name of the petitioner is finding place but in the FIR, but he was arrested by the police, his confessional statement has been recorded, and confessional statement led to recovery of one udar, and this is the reason assigned by the Sessions Court also that udar has been recovered from the house of the petitioner. Therefore, my bail application has been rejected by the
That was a murder weapon.
Ipso facto, police says that it is a murder weapon. But on perusal of the case diary, your lordship will find out that when the place of occurrence where the dead body was lying, no blood is there, and when the spade was recovered from my house, in the spade also, there is no blood. So, how the prosecution is going to say that this spade, which is a kudal, which is a necklace for all farmers and can be found in all the household, how it is a murder weapon? No material in this regard. FSL, for FSL, the material has been sent, but no FSL report is found or has been brought.
blood ही नहीं है तो क्या चीज के लिए FSL में?
Not with blood. This is what the question I have put forth to myself. Not one thing is important. One Acharaj Mahto. Sorry, Asutosh Mahto. He has been examined by the police. Now he becomes himself as an eyewitness for the first time in case time, and his evidence.
FSL में क्या भेजा है?
FSL में कुछ भी नहीं
भेजा क्या है?
भेजा है, लेकिन रिपोर्ट आया है.
क्या भेजा है? वेस्ट्रा की जांच की.
एक तो वेस्ट्रा है और एक पैरा 55 FSL रांची बुधवार रांची पहुंचा, सीलबद्ध जब्त वस्तु प्रदर्श, तो वो हमको लगता है स्पेड हो, तो विधि विज्ञान निर्देशालय एवं प्रयोगशालय झारखंड रांची में जमा किया, तत्पश्चात प्राप्ति रसीद ली. नाउ पैराग्राफ नंबर 23 में काइंडली सीन फॉर अ मोमेंट. पैराग्राफ नंबर 23 मतलब
क्या बोलना है? You have got the information.
but one argument he make and was I must answer it first now, as he has been opening it. Asutosh Mahto Lord is a witness.
Eyewitness.
He says himself to be the eyewitness for the first time.
First time means जब उसका statement record होगा तभी ना बोलेंगे.
My submission is this.
बढ़िया.
My submission is
Para 6 पढ़ेंगे.
आशुतोष महतो.
बढ़िया.
इन्होंने अपने बयान में घटना प्राथमिकी का पूर्ण समर्थन किया. इन्होंने अपने बयान में बताया कि दिनांक 30/10/2025 को सुबह करीब 6 बजे ये और अचरज महतो अपने घर से भैंस चराने के लिए मंगलटाड़ की तरफ गए थे. अचरज महतो बिंदेश्वरी महतो का धान लगे खेत के मेड़ पर अपना भैंस चरा रहे थे, और मैं भी गणेश महतो का धान के खेत के पास अपना भैंस को चढ़ा रहा था. समय सुबह 8 बजे अचरज महतो जहाँ पर भैंस चढ़ा रही थी उसी स्थान पर नकुल महतो वहां पहुंचा, और दोनों के बीच भैंस चराने को लेकर लड़ाई झगड़ा होने लगा. आवाज सुनकर देखे कि नकुल महतो अपने हाथ में रखे लोहा के कुदाल से अचरज महतो को काटने तो
उसके बाद ये वहां जाकर देखे तो देखे कि अचरज महतो के सर के पीछे और कान के पास काट दिया है। नॉट दिस इज जिससे घटनास्थल पर ही उसकी मृत्यु हो गई। और नेक्स्ट दिस इज वेरी इंपॉर्टेंट, इसकी सूचना ग्रामीणों एवं उसके परिवार वालों को दी। अचरज महतो को काटने के बाद नकुल महतो ने गांव में झूठा हल्ला किया कि अचरज महतो को लगभग मार दिया है, जिससे उसकी मृत्यु हो गई है। यह घटना भैंस चराने और पुराने रंजिश के कारण नकुल और सूचना पाकर ग्रामीण एवं परिवार भी उपस्थित हुए और उन सभी को यह घटना के बारे में बताया। So what I failed to understand that if this person has told about this occurrence to the informant and all the other villagers and all the other family members of the deceased, but say that except this witness, all other witnesses have been examined. They have never said that this Ashutosh Mahto has come forward and said that occurrence has taken place in this and this way, and I have seen Nakul Mahto to have assaulted the deceased in this and this manner. Coupled with this, Lord, he says कि लोहा के कुदाल से दो मतलब चोट है, कान के पास और एक सर के पीछे. Now postmortem report says, my lord, he received altogether 6 injuries or 7 injuries, and all of them have been received on the front part of the.
No, head injury.
Head injury है on the frontal portion, on the temporal region.
It is there. It is there. For the learned counsel opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely indicated in this case, and there is no eyewitness to the occurrence. He has further submitted that at the place of occurrence, no blood was recovered, and it is alleged that on the basis of confession statement of the petitioner, the murder weapon has been recovered at the from the house of the petitioner. He submits that the petitioner is in custody.
But I have been in custody since 1/11/2025.
1/11/2025, and charge has already been
Charge has been framed by law on 15/4/2026.
The learned counsel for the state and the informant has submitted that there are eyewitnesses to the occurrence, and they have referred to paragraph 6 of the case diary, submitting that the statement of the witness reveals that he is the eyewitness, and he has supported the prosecution. After hearing the learned counsel for the parties and upon going through the case diary, it appears that there is an eyewitness to the occurrence, and the alleged murder weapon has been recovered from the confession on the basis of confession statement of the petitioner, and the case diary further reveals that the samples have been sent for examination by SFSN, but the report is awaited. In view of the aforesaid facts and circumstances, this court is not inclined to enlarge the petitioner on bail. However, the SFSN branch is directed to ensure that the FSL report is promptly forwarded to the court concerned. The counsel for the state is directed to communicate this order to SFSN.
Item 19, BA 3698 of 2026.
So last of the notices were issued to the appeal number 2, informant.
Opinion number 2, are you for opinion number 2 or you are for the state? Notice has been served. What is the case?
Page number 18 is the FIR matter. May I permit to read it, ma'am?
Yes.
निवेदन पूर्वक कहना है कि मैं विजय थाना चकुलिया जिला पूर्वी सिंहभूम का निवासी हूँ
आज दिनांक 28/7/25 मेरी बहन सेकंड सेट जो अपने सहेली कामी मांडी एवं अन्य सहेली के साथ +2 हाई स्कूल केंद्र नगरी पढ़ने गई थी। मेरी बहन 11वीं कक्षा की छात्रा है। शाम में छुट्टी होने के पश्चात अपने सहेली के साथ घर वापस आ रही थी कि शाम करीब 3 बजे मेरा फोन पर सूचना मिला। कौन सूचना दिया मतलब डायरी में कहीं नहीं आया कि कौन सूचना दिया कि तुम्हारा बहन सुषमा मुर्मू के सिर में चोट लगा है और पूरा खून बह रहा है। मैं अपने परिवार के साथ अपने बहन को लाने के लिए घर से निकले तो घर से कुछ दूरी पर अपने गांव के टोला में राखा घुटन में मिला। उसके सिर से खून बह रहा था। बहन सुषमा मुर्मू से पूछने पर बताया कि जब स्कूल से घर लौटने के समय करीब 3 बजे अपने सहेली के साथ जब ग्राम बड़ा नट्टा पार कर चूड़ी केंचा फुटबॉल मैदान के पास पहुंची, उसी फुटबॉल मैदान जगह पर पहले से आदित्य नायक, मतलब कैसे इसका नाम आ रहा है आदित्य नायक को कैसे जानती है, पहले से कहीं नहीं है डायरी में। आदित्य नायक पिता सेकंड से खड़ा था। मेरी बहन तथा उसकी सहेली का साइकिल रोककर बदतमीजी करने लगा। उसी क्रम में मेरी दोनों सहेली किसी तरह वहां से भाग गई और मुझे आदित्य नायक ने पकड़ लिया और जोर जबरदस्ती करते हुए झाड़ी की तरफ घसीट कर ले गया और दूसरा कम करने का प्रयास किया। जब मैं विरोध किया, चीखी चिल्लाई तो वहां पर बड़े पत्थर उठाकर जान मारने के लिए सर में और हाथ में मारकर गंभीर रूप से घायल कर दिया और घसीटने लगा। वेरी इंपॉर्टेंट, सड़क पर आने वाले लोगों का नजर पड़ा और बचाने के लिए आने लगे तो आदित्य नायक धमकी देते हुए मुझे घायल अवस्था में वहीं छोड़कर भाग गए। नो पर्सन वाज एग्जामिन्ड बाय द पुलिस मैटर, नो स्टेटमेंट रिकॉर्डेड इन केस डायरी। उसके बाद मैडम तो गुजरात लक्ष्मी दोबारा मुझे सूचना देते हुए मेरी बहन को जख्मी अवस्था में लेकर आए। बहन सुषमा मुर्मू को चकुलिया सामुदायिक हॉस्पिटल में भर्ती कराया है, जिसका अभी इलाज चल रहा है। थाना में लिखित आवेदन दे रहा हूँ। आदित्य नायक द्वारा बहन के साथ दुष्कर्म के प्रयास के समय कपड़ा भी फाड़ दिया गया, नॉट सीज, कपड़ा सीज नहीं किया गया मेरा। और मेडिकल रिपोर्ट में भी सिर्फ एक इंजुरी आया, दैट इज हेड इंजुरी मीडियम इन नेचर, नो इंजुरी ऑफ सेक्सुअल असॉल्ट और एनीथिंग।
क्या बोलना आपको?
ये पीड़िता के 180 में बयान तो हुई है ही।
उस पर देखा जाए मेरे उसमें भी बोल रही है, पीड़िता खुद बोली कि इटली वाला एक था,
इटली वाला देख लिया, उसकी आवाज सुन के जो भाग गया।
जो इटली वाला बचाने आया मालूम उसका स्टेटमेंट कहीं के डायरी में नहीं है कि हम बचा रहे हैं या हम देखें।
But the offense could not be committed. Ultimately, the offense could not be committed, and she could escape the offense. Correct?
Yeah.
यही है ना? कस्टडी कब से?
कस्टडी में मतलब 28/7/25 से चार्ज फ्रेम भी हो गया है।
Charge frame heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner summons that the petitioner has been falsely implicated in this case, and as per the allegation, the petitioner had tried to dragged the victim towards the bush and tried to rape her, but when she screamed, the petitioner hit her and ran away from the place of offense. The learned counsel submits that the petitioner is in custody since 28/7/2025. Charge has already been framed
on 10/11/25.
on 10/11/25. The learned counsel for the state has opposed the prayer for bail and has submitted that there is direct allegation against the petitioner. The victim is a student and minor.
Yes.
after hearing the learned counsel for the parties and considering the fact that the petitioner is in custody since 28/7/2025 and charge has already been framed, the petition is eligible to be indicted. No antecedent.
No.
Having no.
Yes, I have taken notice.
Item 20, DA 3742/2026.
कल ही हमको वकालतनामा मिला है इन्फॉर्मेंट के तरफ से, हम रेडी करके लाए या जिस पर केस इसलिए फाइल नहीं हो सका। वही एक अगला डेट।
At the request of the council for the informant, the matter is adjourned and is directed to be posted tomorrow. He is permitted to file the wakalatnama within the course of the day.
Item 21, DA 3778/2026.
This is an application for grant of regulatory, the organization under section 103, subsection 1, and 3, subsection 5 of the bill, that is the 302 and 24 hours. In this case, my lord was pleased to marriage related activity by the counter affidavit. Although the counter affidavit has been filed in this case, and we must be
There is a contract with it.
counter.
नहीं आया इसे। फाइल हुआ है?
हमको तो जो चेक किया गया है 8 तक।
Counsel for the petition submits that a counter affidavit has been filed in this case. Nobody appears on behalf of the state. Office is directed to place the counter affidavit on record and post it.
You can just serve it on this.
I don't know.
It's not yet.
Counter, tomorrow, counter affidavit. तो फाइल क्यों नहीं करते सर?
कभी हुआ है इसे ऑफिस उसको एक्सेप्ट नहीं करता है।
नहीं सर, यहाँ से 1 मिनट में एक्सेप्ट होता है, इसके लिए
नहीं, चूंकि बोर्ड पर 24 घंटे
सर यहाँ से हम लोग सब एक्सेप्ट करते हैं।
This is what I am told.
नहीं मुझे फिर से लिखिए। The counter affidavit has been filed during the court proceedings which is taken on record. हाँ सर बोलिए। Who are you?
I'm not a petition to be followed. But the marriage was solemnized on 1/5/2019. The court notice has been issued. The husband body is also behind the court. The charge sheet has already been submitted in this case, not against the petitioner, and the husband was there taken to custody. The other family members, members of the involved family, they have not been charged sheeted. Investigation has been kept pending in this case. No doubt, not the medical evidence not be shown that the deceased was not had there due to fraud. Suffocation as a result of fraud. The dupatta was found in the room of your room, where not the deceased was residing along with her. On the date of offense, the mother of deceased was present in the sasra, the PO, the house of the deceased.
The mother of deceased was also present.
Also not be present, but not the, that is happened from paragraph 67 of the case diary. That she was present in the sasra of her.
Daughter,
Yeah,
para 67.
of the case diary. That is not the, has been instructed. Paragraph 67 of the case diary. And the so far not the other witnesses who have been examined. They have
Just a
also
moment,
stated.
you please read para 67.
They
Yes, para 67 is very
67.
important.
इस
Her
काम के
statement. हाँ.
साक्षी जैनबिन पति सतुद्दीन या इन्फॉर्मेंट बाय द मदर, ये आगे बताया कि ये मैं नितिका जैनब खातून की मां हूँ। वर्ष 2019 में मेरी बेटी जैनब खातून की निकाह शादी निकाह शेर मोहम्मद शेर आलम पिता आजाद अंसारी साकिब स्वयं के साथ हुई। निकाह के बाद दोनों ठीक ठाक रहने लगे। वर्ष 2020 में जैबुल खातून का पहला बच्चा ऑपरेशन से हुआ था, जिसमें हम लोग करीब 65,000 रुपए खर्च किए थे। इसमें जैबुल खातून के ससुराल वाले आज तक एक भी रुपया वापस नहीं किए। वर्ष 2022 में दूसरा बच्चा हुआ। शादी के बाद से ही शेर मोहम्मद एवं उसके पिता आयाज अंसारी, सास खनीजा बीवी एवं देवर सरताज के द्वारा दहेज के रूप में 2 लाख रुपए और एक गाड़ी, एक मोटरसाइकिल गाड़ी का मांग मेरी पुत्री एवं हम लोगों से बराबर करते आ रहे थे। पैसा और गाड़ी नहीं देने पर महिला थाना सकरपुर में दोनों पक्षों को बुलाकर दोनों पक्षों के बीच समझौता हुआ। समझाने बुझाने पर मेरे दामाद मेरी पुत्री को अपने घर उनके लिए लेकर चले गए। इसके बाद शेर मोहम्मद काम करने तमिलनाडु चले। मेरी पुत्री जयवंत बीवी को उसके देवर के द्वारा तमिलनाडु मेरा दामाद के पास पहुंचा दिया गया। इसी बीच मेरी पुत्री गर्भवती हो गई। तब मेरा दामाद मेरी पुत्री एवं बच्चों को अकेला ट्रेन में बैठाकर वापस भेज दिया। कुछ दिन के बाद जयवंत बीवी का तीसरा बच्चा लड़की हुआ। कुछ दिन मुंगेरी में रहने के बाद जयवंत बीवी एवं बच्चों को उसके देवर के द्वारा मेरे यहाँ इसको पहुंचा दिया गया। जयवंत बीवी की बच्ची का काफी तबीयत खराब हो गया था, जो कि दिनांक 11/12/2025 को सदर अस्पताल में इलाज के दौरान उसकी मृत्यु हुई, जिसकी सूचना हम लोगों ने अपने दामाद और समधी को दी, परंतु वे लोग नहीं आए। तब हम लोगों ने नावा बाजार थाना को सूचना दिया, जिसके बाद थाना द्वारा फोन पर सूचना देने पर समधी आयाज अंसारी और उनके साथ साथ गाँव के लोग आए और मृत बच्चा को अपने साथ ले गए, जिसके साथ मेरे पति एवं हमारी पुत्री जयवंत बीवी था कुछ लोग ही मुंगेरी गए। वहां जाने के बाद समधी के द्वारा मेरे पति को कहा गया कि मेरी पोती का जो हाल हुआ है वही हाल तुम्हारा भी बेटी के साथ हो। इसके बाद मेरे पति एवं ग्रामीण को अपने घर आ गए और इम्पोर्टेंट और मेरी पुत्री जयवंत बीवी वही रहे। दिनांक 13/12/25 को सुबह में टेम्पू से मुंगेरी अपनी बेटी जयवंत खातून के घर मदर हेड गाँव में घर गई। कुछ समय बीतने के बाद घर के बाहर धूप में मैं एवं मेरी बेटी बैठे हुए थे। मेरी बेटी बोली कि तुम यहीं बैठो, हम घर में कुछ काम करते हैं, और घर के अंदर चली। और मैं बाहर दोनों बच्चों के साथ बैठी थी। तब तक मेरी बेटी के ससुराल वाले भी घर के अंदर थे। कुछ समय बाद मैं घर के अंदर जाना चाही तो मेरी बेटी का देवर सरताज अंसारी के द्वारा दरवाजा से गाली गलौज करते हुए मुझे भगा दिया और मैं वहाँ टेम्पो से बैठकर स्कूल चली। उसी दिन समय करीब 7:30 बजे रात में मेरी बेटी सबिला बीवी ग्राम मोदिया थाना जयपुर के द्वारा फोन पर सूचना मिला कि मेरी बेटी खत्म हो गई तथा उन लोगों के द्वारा बिना हमें सूचना दिए मेरी पुत्री।
सर ये बाहर बैठे थे और सब लोग अंदर।
She was not present, but mother was there. But she
Where
said
is
that
the mother-in-law? Mother-in-law कहाँ?
mother-in-law, the Kariya Bibi was there also.
Where is she?
No,
She's absconding. Absconding.
But
आपको पता होगा ना, फादर इन लॉ का केस फाइल कर रहे हैं तो मदर इन लॉ कहाँ है तो पता होना चाहिए ना। तो पूछे ही होंगे। हस्बैंड के बारे में बता रहे हैं कि जेल में है, मदर इन लॉ कहाँ?
मदर इन लॉ का इन्वेस्टिगेशन चल रहा है, वो अच्छा है, वो
चलेगा ना, क्योंकि वो पकड़ा ही नहीं।
तो उसको पूछा गया, हम नहीं समझ पाए। मदर इन लॉ बाहर में अभी तो इन्वेस्टिगेशन चल रहा है। कहे कि जो चार्जशीट आया है, चार्जशीट में मेंशन दैट 2 persons were charged, the father-in-law and the period of 90 days was going to expire. That's why they have submitted this charge sheet against each person who had taken to custody. So far, the others are concerned.
That is why I'm asking, where is देवर ने तो उनको घुसने नहीं दिया घर में।
मदर-इन-लॉ के बारे में तो कुछ नहीं बोली। मदर-इन-लॉ का क्या रोल था?
Everybody was there inside the house. This is what she is saying. And she was sitting outside with the children.
Yeah. So far not this present petitioner is concerned.
Sir, mother-in-law का bail पहले कराइएगा, उसके बाद father-in-law.
तो जब तक ये हम father-in-law का क्या
ऐसा नहीं है, नहीं है। Allegation यही है कि father-in-law has stated that the same treatment will be given as has been given to the पोती के साथ जो हुआ है वही आपकी बेटी के साथ होने वाला है।
ये I don't that There is nothing that not or that not the.
She died
his
within
father.
7 years of marriage? Correct.
1/5/2019 को निकाल हुआ था.
Within 7 years
Yes,
from
within
here.
7.
For the
But
learned
the-
councils.
That this father-in-law not the except that not he had not the under not the provocation. Certain provocation or not the provocation not he was under the shock because of the death of not the daughter granddaughter. They had not taken care of. And not thereafter not the he might have stated कि तुम्हारी हमारी पुत्री को तुम मार दी तुम्हारा लोगों का वही असर. But that doesn't mean that not the father-in-law had committed not the. But not fact that the patta from which not the other witnesses have been examined, paragraph 93 onwards, and not the BAs have also stated कि सुने क्यों आत्महत्या कर ली. Thereafter not the I am not disputing at this stage the finding of the doctor. Doctor has said that they thought that she died because of suffocation due to throttling, and the patta was not kept inside. So that was not found in the room where not she was related. The deceased. Not from the room of not the present, not the petitioner.
Copy as a
That was
photo.
secured.
For the learned councils appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the father-in-law of the victim and the marriage was organized on 1/5/2019. He has submitted that there is general and omnibus allegation against all the accused persons, including the husband of the victim who is in custody. So far as the mother-in-law is concerned, she has not been taken into custody so far. The learned counsel further submits that the father-in-law has no role to play in this case. And charge sheet has been submitted against the present petitioner and the husband. And further investigation is going against the other co-accused, including the brother-in-law and mother-in-law of the victim. The learned counsel for the state has opposed a prayer for bail and has submitted that the mother of the victim, the statement of the mother of the victim has been recorded in para 67 of the case diary, which reveals that the victim had left her mother outside the house and went with children and went inside the house to complete certain work, and she and all the family members were inside the house, and she was found dead in her matrimonial house. It has also come in a statement that when she wanted to enter the house, the brother-in-law had forced her to go back to her house, to her own house. After hearing the learned counsel for the parties, and he has also submitted that there is an allegation against the father-in-law with regard to demand of dowry, and he had also threatened that the victim would meet the same fate as the deceased granddaughter. After hearing the learned counsel for the parties and considering the fact that the victim was found dead in matrimonial house and she died of throttling, and also the dupatta which was alleged to have been used for the commission of the offence was recovered at the instance of the petitioner, and there is direct allegation of demand of dowry, which includes the petitioner as well. This court is not inclined to enlarge the petitioner on bail. So mother-in-law, Sasuma is important. husband से भी ज़्यादा important role सासू माँ का है in all these kind of cases. They have a great role to play and they have lot of responsibility to discharge. As I understand from the social fabric.
Item 22, BA 3782 of 2026, along with item 23 and 24.
काउंटर का डायरेक्शन होता कल ही रिसीव किया काउंटर को नहीं कर
कब करना है? कब करना है? At the instance of the learned counsel for the opposite party. Let these cases be posted on next Wednesday. The counter affidavit be filed latest by next Monday. यहाँ पे देख के फाइल.
next case
Wednesday.
counter already filed. You say received the
In which
counter.
case? अभी फाइल नहीं हुआ.
In one of the cases with counter already filed, I received that copy of the
एक साथ कर.
the report from day one.
So it was granted bail also.
So done.
24 days.
22.
सब एक साथ है ना?
जी.
सब एक साथ ही कर.
Item 25, BA 3816 of 2026.
Yes,
Offenses under section 85 and 52. It has something which requires that internal take 60 hours. It has been mentioned. He has alleged that the marriage with the petitioner happens to be the husband of the deceased worship was solemnized 4 years prior to the date of occurrence. Thereafter, worship the petitioner, along with his father and mother, used to torture her for demand of dowry. No amount has been mentioned in the entire FIR video, or what amount was demanded by her. But thereafter, there was this Mahindra Thana case registered in the month of October 2025, which was made a compromise between the parties. And on thereafter, on 8th of January, they received information from the villagers that she had died due to electrocution. The same has been supported by the independent witnesses who have been examined at Para Committee 29, 30 and 30. They have clearly stated that after the compromise was done between the husband and the wife, they had cordial relation between each other. They also have a 3-year-old daughter, Roger, and she died as a result of electrocution. So my humble submission is in the laws that the victim lady died as a
cause of death. Cause of death.
Not cause of death is also the same, Roger. There's nothing clear in my laws. Where no other injury has been found, death is due to electrocution and its associated complications.
You read the FIR. This is the second case, right? In the earlier there was a compromise. इसमें जरा FIR
निवेदन पूर्वक सूचित करता हूँ कि मैं सुरेंद्र राम तेरा सोम से सुनते निवासी हूँ। आगे मैं अपनी पुत्री किरण कुमारी की शादी लगभग 4 वर्ष पूर्व अनुज कुमार से पिता सोमसो के साथ हिंदू रीति रिवाज के साथ हुई थी, जिससे एक बच्ची की जन्म हुई है। उसकी उम्र लगभग 3 वर्ष है। आगे शादी के बाद से ही मेरा दामाद अनुज कुमार पिता सोमसो देवी पति सोमसो दहेज के लिए मेरी बेटी किरण को काफी मारपीट एवं प्रताड़ना देते रहते थे कि मायके से रुपए लाकर मुझे एवं मेरे माँ बाप को दो, नहीं तो तुम्हें जिंदा नहीं छोड़ेंगे, किसी भी समय तुम्हारी हत्या कर देंगे, कोई हम लोग का कुछ भी नहीं बिगाड़ पाएगा। शादी के बाद कई बार प्रताड़ना करने पर ग्रामीणों एवं गणमान्य लोगों के बीच पंचायत एवं समझौता भी हुआ था, लेकिन ये लोग मेरे लड़की को प्रताड़ित करते रहे एवं जान मारने की धमकी देते रहे। अभी कुछ माह पहले दिनांक 12 अक्टूबर 2025 को महिला थाना गढ़वा में मैंने मारपीट एवं प्रताड़ना दहेज मांगने के संबंध में आवेदन दिया था, जिसमें समझौता कर एवं यह आश्वासन देकर कि आप लड़की को किसी प्रकार की प्रताड़ना नहीं करेंगे, विदाई कर।
Where is the postmortem report? Any antemortem injuries?
No other injury has been found.
आपने फाइल किया काउंटर? Yes, what is the cause of death? Is there any antemortem injuries?
Para 10 years mentioned Worship. As per the opinion of the doctor, death is due to electrocution.
क्या बोलना है आप इंफॉर्मेंट है क्या बोलना है
इसमें नोटिस टू घटना स्थल पे बिजली का तार ऐसा नहीं आया है। दो जगह पारा 8 और पारा 67 में आया है आयुक्त अवलोकन में और घटना स्थल की जांच में कि आसपास में बिजली का तार नहीं है। और
लेकिन
इसमें
कॉज ऑफ डेथ तो इलेक्ट्रोक्यूशन
कैसे मरी है ये करंट लगा के मारा है या लगा कैसे
तो करंट
ये
लगा के
clear नहीं
मारी है
हो पा
तो
रहा
बिना तार के तो करंट नहीं लग जाएगा ना
हो सकता है घटना के बाद इधर उधर कर दिए होंगे और लगातार ये टॉर्चर किए हैं। कई बार हम लोग समझौता किए हैं उससे पहले एफआईआर हम लोग थाने में किए हैं। ये लगातार इस तरह के किए हैं। पहले से इनका कंडक्ट मेरे प्रति अच्छा नहीं रहा है बराबर ये हमको परेशान करते रहे।
इसीलिए पूछ रहे कोई एंटीमॉर्टम इंजरी है क्या
उसमें तो नहीं आया अभी
नहीं आया ना तो ऐसा नहीं है कि जबरदस्ती मार पीट के वहां पे तार लगा दिए ऐसा तो नहीं है
लेकिन घटना स्थल पे ये आसपास बिजली के तार का नहीं आया। पारा 67 में है और पारा 8 में है।
बट शी डाइड ऑफ इलेक्ट्रोक्यूशन कब से कस्टडी है आपकी
Custody since 13 to 26. Independent investigation comes forward to state about the case.
चार्जशीट हो गया व्हाट इज द स्टेज ऑफ द केस
Yes.
Stage? चार्जशीट
On a charge case.
Heard the learned counsels appearing on behalf of the parties. The counsel for the petition submits that that there was matrimonial discord and earlier earlier a case was registered in Mahila Thana on 12/10/2025 regarding torture and demand of dowry, which ended in a compromise. And after 2.5 months from compromise, the victim died due to electrocution. The learned counsel submits that there is no antemortem injury and apparently it is an accidental death. Okay? The learned counsel for the informant has opposed the pair and they have submitted that there was continuous demand of dowry and torture of the victim, and she died within 7 years of marriage in matrimonial home. Under such circumstances, the petitioner may not be released on bail. He has also submitted that even the wire through which the electrocution of the victim would have been there has not been recovered from the place of occurrence. It goes to show that the accused persons have tempered with the evidence. Right? The learned counsel for the state has also opposed the prayer for bail. After hearing the learned counsel for the parties and it is not in dispute that there was matrimonial discord which ended in a compromise and the victim was living in her matrimonial home And as per the postmortem report, the victim died of electrocution. But no antemortem, and further no antemortem injury has been found. Considering the fact that charge has already been submitted, the petitioner is directed to the enlargement.
Item 26, DA 3874 of 2026.
Also for the petitioner says that we should withdraw this bail application to this business.
Sign for me. Sign for me. Item 27, DA 3880 of 2026.
This petition.
This was the last occasion is very criminal and disciplinary for
What is the case against it?
the offense under section 103 clause 1 to 38 and clause 3, section 3 and 5 of the BNS. Petitioner is the not naming the FIR lawsuit as being has transpired on the basis of the conditional statement of the co-accused also. One of the co-accused during the investigation, one of the co-accused arrested by the police, and she has disclosed the name of the petitioner as a Sahyogi. She is only stated, except that other witnesses also stated the same thing. And he was arrested by the police along with his mobile phone. That is the under.
Who was arrested? The mobile phone of the victim?
No, his own mobile.
Okay. So?
Because this is the case, no criminal antecedent.
Read the FIR.
Yes. उपरोक्त विषय के संबंध में निबंधन पूर्वक कहना है कि मैं राहुल अंसारी जिला गिरिडीह का स्थायी निवासी हूँ। आज से 4 वर्ष पूर्व हम अपनी बेटी साइना परवीन इस वर्ष जावेद अंसारी पिता साबिर अंसारी का शादी मुस्लिम विद्यार्थी के साथ संपन्न हुआ। शादी के बाद दोनों के प्रेम मिलाप से एक अंसारी लड़का हुआ जिसका उम्र करीब 2 वर्ष है। उसके बाद से मेरी बेटी का ससुराल बराबर घरेलू विवाद को लेकर मारपीट करते रहता था और खाना पीना नहीं देता था। यहाँ तक कि कई बार मायके से 2 लाख रुपए भैंस लाने के लिए बोलते रहता था। जब मेरी बेटी मायके से रुपये लाने से असमर्थ दिखती थी तो ससुराल वाले बेदर्दी से मारपीट करता था। इस विषय में बिल्कुल थाना में माउंट भी हुआ था, लेकिन मेरी बेटी का ससुराल वालों में कोई सुधार नहीं हुआ। मेरी बेटी साइना परवीन उम्र करीब 21 वर्ष पिता राहुल अंसारी ने दिनांक 28/2026 से घर से लापता थी। उसके बाद हम सब परिवार पड़ोस और रिश्तेदार को खोजने किए, लेकिन कोई पता नहीं चला। उसके बाद हम परिवार डूंगरी थाना में दिनांक 29/1/26 को गुमशुदगी का आवेदन दिए। दिनांक 30/1/26 को करीब 1 बजे सुबह में सोशल मीडिया के द्वारा पता चला कि गाड़ी का अधिक जंगल थाना बगोदर जिला गिरिडीह में अज्ञात लड़की का शव है तो हम सब परिवार गाड़ी जंगल गया और लड़की का बॉडी पूरी तरह से जला हुआ था, लेकिन बैग का उंगली एवं से पहचान की कि साइना परवीन है जो विगत 3 दिनों में लापता थी। जो हम सब परिवार को पूर्ण विश्वास है कि मेरी पुत्री साइना परवीन को पति जावेद अंसारी पिता साबिर अंसारी लड़की के साथ सैगुन खातून पति साबिर अंसारी लड़की का ससुर साबिर अंसारी पिता स्वर्गीय चरक मियां देवर वसीम अंसारी पिता साबिर अंसारी पोती राना परवीन पति वसीम अंसारी अलाउद्दीन अंसारी पिता निजामुद्दीन अंसारी सभी साथी चीनों थाना जिला गिरिडीह शुक्रुद्दीन अंसारी पिता इब्राहिम अंसारी नंद चांदी खातून पति समीम अंसारी दोनों साथी बरवाड़ी थाना बगोदर जिला गिरिडीह सभी ससुराल वालों ने मिलकर मेरी बेटी को पहले जान मार दिया और सच छिपाने के लिए।
So who are you? You are not named in the FIR.
No,
who are you?
no,
You are
he's
the
not
third person.
Is
You are
not
not a family member.
no, neither related nor any connection with the family member of the deceased.
Jabir Ansari, right? आपका क्या रोल?
मेरा इस ये है वो जो वकील अंसारी।
वकील अंसारी।
कोई रोल नहीं है, इनका नाम आया है confessional statement. The confessional statement of the mother-in-law of the deceased.
What does she say?
Nothing. She has simply stated the first line सहयोगी में खाली नाम लिया वकील आंसर. After that, she has not stated anything about the lordship. What role has been attributed by this petition?
क्या बोल रहे हैं आप?
ओनली कन्फ्यूजन इसमें किसी नाम आया अब कन्फ्यूजन इसमें कुछ सहयोग क्या है तो भी भेजने को
कन्फेशन स्टेटमेंट से क्या करेंगे आप? हाउ विल यू सिक्योर हिज कन्विक्शन? कुछ भी नहीं. आप कौन स्टेट
कैसे हम लोग मतलब जनरली हमारा
therefore the
information
inform. What do you have to say? इनके अगेंस्ट में क्या है? He is not the family member.
फैमिली मेंबर नहीं लोग. इसके अगेंस्ट में यही है कि शराफत अंसारी ने 50,000 रुपया लिया था और उसका सहयोगी में ये वकील है गुड्डू है. ये तीनों मारने में एलिगेशन मारने का यही लोग मारा है. इन लोग 50,000 एडवांस लिया और मुंबई में काम करता था. वहां से आया और ले जाकर के जंगल में यही लोग मारा है. मार के पहले गाड़ दिया फिर बाद में छुपाने के लिए उसको जला.
कुछ रिकवरी है इनसे?
इसके पास है नहीं कोई. इसके पास से कोई रिकवरी नहीं.
कोई एंटीसीडेंट है इनका इस तरह का? कोई बैकग्राउंड? कोई एंटीसीडेंट है? कस्टडी कब से है आपका?
5/2/2026. I have stated in my petition also part
5/2/26.
Yes.
Charged हो चुका होगा.
हो चुका.
Heard the learned counsels opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is not named in the FIR and is not a family member of the victim. It submits that the name of the petitioner has transpired in the confession statement of the mother-in-law of the victim.
Yes, sir.
And consequently, he was arrested and his confession statement was also recorded. But apart from that, there is nothing against the petitioner to connect the petitioner with the arrest offense. The learned counsel for the state as well as the informant has opposed the prayer for bail and has submitted that. However, the aforesaid submissions made by the counsel for the petition is not in dispute. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, that apart from confession statement, there is nothing against the petitioner, and the petitioner is admittedly not a family member of the victim. The charge sheet has already been submitted.
Yes, sir.
And petitioner has no criminal antecedent
No
as
criminal
submitted by the counsel.
I have stated in volunteering also. No
The
criminal.
petitioner is eligible to be indicted.
Item 28, DA.09.09 of 2026.
Counsel for the informant. At the instance of the learned counsel for the informing, the matter is directed to be posted tomorrow. He undertakes to file wakalatnama. He is permitted to file wakalatnama during the course of the day.
In the meantime, copy of bill
आप
application.
दे दीजिए इनको बेल एप्लीकेशन तो कॉपी नहीं दीजिएगा तो फिर 1 महीना अटेंड कर दूंगी
आज ही
Item 29, BA 3938 of 2026.
On last occasion, case diary was confirmed. The matter released to 376-2 and stalking. The victim is a married lady and she has stated in FIR that she has been in love affair for 2 years. And after 2 years, this false case has been registered only on that basis that her husband got knowledge of their relationship. Thereafter, this case has been distributed, and the allegation is that I have made a photo viral. That photo is selfie, and that mobile has also been seized. Charge sheet has also been submitted. There's no criminal antecedent as well, and the petitioner is unmarried.
Yes, it is a state. Heard the learned counsel pleading on behalf of the Very state. Contract limit has not been filed. Counsel for the state is absent. No contract limit has been filed in terms of order dated 11/5/2026. Close this case on next text. Let a copy of this order be communicated to soft copy to Mr. Salim Kumar, Counsel for the state.
Item 30, BA 3941 of 2026.
I received wakalatnama.
My mother.
Counsel for the informant is
Mother of the petitioner is seriously sick. She is in hospital and therefore I short date maybe.
short date मतलब
Yes, कल.
आज वकालतनामा फाइल करेंगे. Counsel for the informant is present. He is submitted to file wakalatnama during the course of the day.
काउंटर भी फाइल करना है इसमें हुआ था.
काउंटर का क्या करना है? तो ये तो अभी आपके रूल आप क्या करेंगे? बाकी आपके पास केस डायरी आ गया है?
Yes, I have the case study and counter has been filed on marriage.
You have filed your
Yes,
contract
it
limit.
yes, it has already been filed.
But I also have to file counter. Maybe on Monday or Tuesday.
काउंटर नहीं हो सकता. आपको केस डायरी है, केस डायरी से होगी. आपका नया काउंटर क्या दिखेगा? केस डायरी के अलावा क्या होगा?
Absconder थे 5 साल से शादी करने के बाद. He has been granted bail on the ground that he will perform marriage with the.
We'll see that. ये काफी है रिजेक्ट करने के लिए भी ना. काउंटर का क्या काम?
I have filed everything, all the records I have filed, which he can add, which will already I have informed you. But
Passover case from the supplementary list, item 2, BA 4126 of 2026.
Initially, the file has been registered under section 64(1), 350(1)(2) and 354 means.
Trial is on. Trial is going on.
Yes.
There is a direct allegation against you.
Yes. Now, make ID being
आप
allowed
बताइए.
to place election number 2.
Yes, what is it?
The husband of the informant has assaulted the petitioner on the relevant date, that is on 26th of October 2025, and he was admitted to the hospital at 10:30 in the morning. Thereafter, on the 28th, there is a delay of 2 days in lodging of present.
On 28th.
Yes, showing that the present incident has occurred on 26th at 8:30 in the morning. That is an FIR at page number 19.
From where do you say that the husband had assaulted her? From Manekshipur?
This is the report, medical report.
That husband has assaulted.
I will made a specific statement.
Well, after statement से क्या होगा? How do you say that the husband had assaulted?
he was
डेट ऑफ इंसिडेंट कब का है? 26 तारीख का है.
26 को उसको मार करके he was at semi-conscious state, he was admitted to the hospital and he was also arrested from the hospital and he has went for
सेमी कॉन्शियस स्टेट में कौन था? 26 तारीख
petitioner मोरिया पहाड़िया 26/10/10:30 AM semi-conscious physical assault. And the case diary has come at paragraph.
But not any mark on the body. But no injury. Physical assault without injury.
They are being referred to Sadar Hospital also.
Yes.
ये सामूहिक सेंटर पे बात दे रहा है सदर हॉस्पिटल.
फिर क्या
वहाँ पे अल्ट्रासाउंड करने के लिए बोला पेज नंबर 29.
फिर क्या हुआ?
फिर हम अल्ट्रासाउंड के लिए गए, इलाज कराया, फिर आपने was arrested from the hospital campus on the 14th.
क्या एलिगेशन है आपके?
एलिगेशन है कि हम when the informant has went for a nature's call, thereafter the petitioner has committed. There is no sign, external or internal injuries, कुछ भी नहीं है. That is the point by the doctor.
आपका ये सब डॉक्यूमेंट पेज डायरी में आया? क्या पर
डायरी में आया है, पेज नंबर 32 में आया, जो को गिरफ्तार किए गए हैं तो सदर अस्पताल कैंपस में कहा गया जिसे विधिवत से गिरफ्तार किया गया और उसमें मेरे पास से 7 डॉक्यूमेंट मिला है मेरे इलाज का. That is part of the diary.
What is the reason of false imputation? Is there any reason for false imputation?
जो out of the court lawsuit they were already in a relationship. और जब पता चला तो सीधा मारपीट हुआ.
Court will then counsel appealing on behalf of the parties. The learned counsel for the petition submits that the petitioner had been falsely implicated in this case and on 26/10/2025 at 10:30 AM he was admitted in the primary health center, community health center in unconscious stage, and then he was referred to Sadar Hospital Sahibganj for further examination. It says that the petitioner was arrested from Sadar Hospital Sahibganj. The learned counsel and he has been falsely implicated in this case. The learned counsel for the state has opposed the prayer for bail and has submitted that the incident is at 8 AM on 26/10/2025 and there is direct allegation against the petitioner of committing rape upon the victim. He has also submitted that the trial is going on and a few witnesses have also been examined.
No notice. Charge has not been framed till date. Next date is on.
Charge has not been framed.
No, on 22nd of June 2026. Next date. Altogether there are 7 notices. No notice.
The learned counsel for the petition has also submitted that the charge sheet has been submitted, but charge is not been raised. After hearing the learned counsel, for the parties and considering the direct allegation of rape made against the petitioner, this court is not inclined to enlarge the petition on bail henceforth. It is always at this stage. That's all.